Welcome, everybody. Welcome, finally. Sorry about the delay. To the Law of Self-Defense show. I am, of course, attorney Andrew Branca for the Law of Self-Defense. So you could all be here today. My morning got a little complicated, hence the 10-minute delay in starting the show. But here we are. Here we are. Let me just pin this over here. Make sure this is streaming over there. And it should be, everything's working right. Great. Awesome. So, of course, we're here today to talk about this. A full day, pretty much, of Alec Baldwin hearings. Alec Baldwin, of course, is the actor. Actually, I don't mind Alec Baldwin's acting. He was good in Red October. Actor Alec Baldwin, charged with involuntary manslaughter by the state of New Mexico over his shooting death of cinematographer Halyna Hutchins on the movie set of Rust. And because he was holding in his hand what he knew to be a real gun, pointed that real gun directly at Halyna Hutchins, never confirmed there was no live ammo in the gun, manipulated the hammer, arguably manipulated the trigger. In any case, discharged the gun, fired a live round that struck Halyna Hutchins in the right armpit, traversed her body, breaking her spine. The bullet exited the left side of her body, then entered the body of director Joel Souza, standing behind her, embedded itself in his shoulder. He would survive that gunshot injury. Halyna Hutchins would not. And the state of New Mexico is appointed as a special prosecutor, Carrie Morrissey, normally a defense attorney, but appointed as a special prosecutor for this case. She previously prosecuted the Rust set armorer, Hannah Gutierrez, for involuntary manslaughter in this matter. Just a month or two ago, convicted her. And Hannah Gutierrez was sentenced to 18 months in prison by the judge, Judge Sommer, and is currently serving that sentence. Now it's Alec Baldwin's turn. Alec Baldwin appears to have hired much better lawyers than did Hannah Gutierrez. Jason Bowles was Hannah Gutierrez's lawyer, thoroughly unimpressed by his performance, not only at trial, but at pre-trial investigative hearings between his client and investigators, in which at times Jason Bowles appeared to be playing on his phone rather than governing the framework of the interrogation, which is his job, in my opinion, as the counsel for his client. She said many damaging things in that interrogation that were used against her in court. He's still her lawyer, by the way. There's a lot going on here. One of the things going on is that the state wants to try to compel Hannah Gutierrez to testify in the Alec Baldwin trial. She has stated through counsel that she intends to plead the Fifth Amendment if she's called to testify. But you're not allowed to plead the Fifth for just anything. You're only allowed to plead the Fifth for things that could incriminate you. And if you're granted immunity, so those things can't be used against you, well, then you have to testify about that stuff too, or be held in contempt of court. So that's one of the issues we'll be talking about today. Today will be two sessions, so there'll be two separate shows, just to give myself a break. The morning session is going to be the hearing on defendant's expedited motion to exclude witnesses. That's first. That's at 9 o'clock. So at the top of this hour, 9 o'clock Mountain Time. And that's an interesting one because apparently the defense had listed on its witness list, each party has to notify each other of their witnesses, their planned witnesses, so that the opposing counsel can prepare for cross-examination of those witnesses, impeachment of those witnesses. The defense had listed a bunch of witnesses and then interviewed them pre-trial. And during the interviews, the defense realized, oh my gosh, these witnesses are going to say things that are very damaging to our client, defendant Alec Baldwin. So they decided they would remove them from the witness list. And now the state is saying, no. We want those witnesses now. So the defense is trying to get those witnesses excluded. The second thing that'll happen this morning is that motion for immunity for Hannah Gutierrez that I just referenced. By the way, folks, it's important to understand that all this stuff that's happening today and everything that's happened so far with respect to Alec Baldwin, all these pre-trial hearings and motions, and of course, motions are just a request to the judge for a decision, for an order on something. All of this sounds kind of technical and administrative, and in some respects it is. But these pretrial proceedings are often critically important because they define the legal battlefield of the trial. So if all you watch is the trial, then you don't know what witnesses might have been excluded or what immunity might have been allowed or not allowed in a particular case. It's almost like before a football game, the teams get to argue about what the size and shape of the field should look like, the playing field, and how goals are scored or not scored. All those rules for the game in a trial, the game of a trial, are defined in the context of these pretrial proceedings. So this is all critically important stuff. This will decide what arguments and evidence the jury gets to see and consider in arriving at a verdict of guilty or not guilty in this case. So that'll be the morning session and part one of this two-part series of shows. The motion to exclude witnesses, the defense wants to keep witnesses out of the trial, and the state's motion to compel Halyna Hutchins to testify by providing her with immunity, which the defense opposes because the defense has the reasonable expectation that Halyna Hutchins is going to testify about stuff that's very harmful to their client. Then probably around lunchtime, Mountain Time, the court will take a break. I'll take a break then too, grab something to eat. And this afternoon at 1 p.m. Mountain Time, so 3 p.m. Central Time, I think actually a half an hour before that. So let's say 12:30 Mountain Time, 2:30 Eastern Time, we'll start part two of this two-part series of shows. The court is scheduled to come back into session at the top of that hour, and there'll be two more issues discussed and argued before the judge. Pretty long ones. So one of them is the defendant's motion to dismiss the indictment for failure to state a criminal offense. Really, I thought this had been argued already, but maybe the defense has another argument why what Alec Baldwin simply did is simply not a crime as a matter of law. And the second motion, 2 hours scheduled for this final motion. It's the biggest block of time. Is defendant's motion to dismiss indictment with prejudice based on the state's destruction of evidence. So the destruction of evidence part is that the state sent to the FBI labs the revolver that Alec Baldwin used to kill Halyna Hutchins for testing, primarily to see if the gun could be basically unintentionally discharged without the trigger being pressed. And in the course of that testing, the FBI lab managed to break internal parts of the gun. That's what the defense is calling destruction of evidence. And they're asking that the judge here, Judge Sommer, dismiss the indictment with prejudice. With prejudice means that Alec Baldwin could not be reindicted. This case would be over for Alec Baldwin. He would be clear of all criminal liability for the killing of Halyna Hutchins. 2 hours allowed in that for argument. So that's what we'll do this afternoon. So now let me make sure I can pull up the stream for the court. It still says upcoming in 10 minutes. All right, so I have it ready. And I'll try to answer questions from the Law of Self-Defense membership during breaks. Actually, before I jump into that, let me do the formal launch of today's show. Here we go. Well, my little video didn't work correctly. It should have ended up looking like this, which of course you've all been watching. But more to the point, today's show is brought to us, sponsored. Today's Law of Self-Defense show is sponsored by CCW Safe, longtime partner of mine. I do a lot of collaborative work with CCW Safe. Think the world of those guys. CCW Safe provides legal service memberships, what many people mistakenly call self-defense insurance. In effect, CCW Safe promises to cover their members' legal expenses if they're involved in a use of force event. And they do much more than that. They fly in, wherever you are, they fly in their own investigative team, experienced homicide detectives. So you have investigators working for you, interviewing witnesses, trying to find evidence. Otherwise, the only investigators working on the case work for the state, the prosecutor. That's not great. They also have Don West as their national trial counsel. Attorney Don West was one of George Zimmerman's defense counsel. That was a perfect legal defense. I didn't know Don at the time of the Zimmerman trial, but we've become good friends since then. And I think the world of Don as a criminal defense attorney. Any defense with Don advising them is head and shoulders above a defense that doesn't have Don advising them. That all comes as part of being a CCW Safe member. More important, I trust them. I trust CCW Safe to do what they say they're going to do. Now, there are other companies out there in the marketplace that purport to offer similar services. Some of them are reasonable options. CCW Safe is not going to be the perfect fit for everybody. Everybody has different needs and budgets and so forth. So there are other alternatives worth considering for sure. There are also other alternatives in the marketplace that are hot garbage that I couldn't recommend to my worst enemy in good faith. So be careful about what you pick. Know what you're buying. I trust CCW Safe. I'm personally a member of CCW Safe. My wife, Emily, is personally a member. I trust them to have my back, to have our back should the worst happen. Should I be compelled to use force to defend myself, my family, or my property? If you'd like to learn why, specifically, I trust CCW Safe, why I chose them as the best fit for me, you can point your browser to lawofselfdefense.com/trust. Easy enough to remember. I have a very short video there where I detail why I chose CCW Safe, why I trust them. And at that same URL, lawofselfdefense.com/trust, you can also get a 10% discount code for your own membership at CCW Safe. Right there at the bottom of the URL, at the bottom of the screen, lawofselfdefense.com/trust. All right, so where are you? New Mexico, still pending. I've got the window open here. I will, from time to time, as we take breaks, address questions from the Law of Self-Defense membership. You need to be a Law of Self-Defense member because we live stream this to YouTube, to Twitter, to Rumble, but most importantly, to our Law of Self-Defense members. There's a member-only live stream with a member-only chat, and that's where I look for questions and comments to address. The good news is you can become a Law of Self-Defense member dirt cheap for just 99 cents. 99 cents for a 2-week trial membership. Get all your questions and comments answered for free. Get access to thousands of our videos and blog posts, our entire archive. Get transcripts of every show that you can download so you can document what you've learned as a Law of Self-Defense member should you ever need to introduce that specialized knowledge in court as part of your legal defense, and much, much more. Try it out for 2 weeks for 99 cents. After the 2 weeks, it's still dirt cheap, folks. It's only 30 cents a day, less than $10 a month to be a Law of Self-Defense member. But at the very least, try it out for 99 cents at lawofselfdefense.com/trial. You'll be immediately emailed instructions for how to join us on the live chat, on the member chat, which I'll take a look at right now. So apologies to the members in particular, but everybody else as well. For being 5 or 10 minutes late this morning. I had some stuff come up at the last minute that I had to address, but we are here now. Let's see. Pamela asks, if you're asking me, Pamela, have you watched the Florida versus Michael Drake trial? I live streamed the entire trial. Pamela. So yes, I watched it, every minute of it, and covered it, live blogging, live streaming, did blog posts on it. So yeah, that's all in our archives. Let's see. Why can't Eric says, you may have said this already, but why can't the state just call the witnesses the defense is trying to exclude? If it's for cross-exam reasons, can't the defense just keep them on their list and not call them? Well, we're going to hear these arguments, but there's a deadline for notifying the court and opposing counsel of what your witnesses are going to be, because the opposing counsel needs time to prepare to cross-examine and impeach that witness. So after the deadline, you can't add witnesses anymore. The defense is saying that the state missed the deadline to add witnesses. The state is saying, well, no, we included in our witness list a caveat that our witness list incorporates every witness listed by the defense. We're reserving the option to call them. And the defense is saying, but then you said you reserved the option to exclude them, and then the deadline passed, and now it's too late for us to interview these, what were their own witnesses. Of course, they did interview these witnesses. That's why they knew they had bad things to say for their client. So this is really all just smoke and mirrors, sleight of hand by the defense, sleight of hand by the defense. Lots of that going on here because if we just look at the facts in the law, Alec Baldwin screwed, in my opinion. I wrote my first analysis of this shooting the day after it happened. I wrote my first analysis October 22nd, 2021. And I said, unless there's some bizarre explanation, like a piece of the set collapsed and fell on Alec Baldwin, which is what made the gun discharge. So it's a genuine accident. Unless there's something like that, this looks like involuntary manslaughter every day of the week and twice on Sunday. And I've seen nothing in the evidence since then that does anything but reinforce my initial take on this. This is just on the law and facts of this case. This is simply involuntary manslaughter. No question about it. So on the facts in the law, the defense is screwed. So there's a cliche in the law. When the facts are on your side, you argue the facts. You pound the facts. When the law is on your side, you pound the law. And when neither is on your side, you pound the table. And the defense is doing a lot of table pounding here. And I don't blame them for that. Their ethical obligation to their client is to zealously represent the interests of their client and to the greatest extent they possibly can within ethical boundaries. And they're certainly doing that. I mean, I think they're pushing some of these ethical boundaries. But nevertheless, that's their job. If I were in their position, I'm not sure I'd be doing anything different. That doesn't mean what they're doing has legal merit, is legally sound, or likely to be effective. They don't have much to work with. It's one of the reasons we encourage all of you to become a member of the law of self-defense community, become informed about your privilege for self-defense. Get our book, Law of Self-Defense Principles, for free. Check it out on Amazon. The 5-star reviewed, 1,500 or so reviews. Very easy to read. Most people read it in an afternoon. Covers most everything you need to know about your privilege to use force in self-defense, maybe 80% of what you need to know. Now, don't buy it on Amazon. They'll charge you for the book, I think $20 or $25 plus shipping and handling. We'll give you the book for free. We only ask you to cover the cost of shipping and handling. But if you don't know this stuff, you don't know what your privilege to use force in defense of yourself, your family, your property is. And you'll end up giving your lawyer bad facts. Like Alec Baldwin is giving his lawyers bad facts. And if you give your lawyer bad facts, it's a tough day for that lawyer in court. They're stuck. They don't have a time machine. They don't get to go back in time and change what you did or change what you said. They're stuck with the facts you give them. So you want to give your lawyer good facts. Great way to do that. Right there at the bottom of the screen. Get this book for free at lawofselfdefense.com/free book. Easy enough. Lawofselfdefense.com/free book. Give your lawyer good facts. If you give your lawyer good facts, you make yourself hard to convict. I mean, that's our catchphrase here at Law of Self-Defense. You carry a gun so you're hard to kill. Know the law so you're hard to convict. Whoops. Sorry. Little disorienting, I would imagine. So that's the top of the hour. Still waiting for the New Mexico court feed, folks. If you give your lawyer good facts and he can raise a robust legal defense of self-defense, the state has to disprove that beyond any reasonable doubt. That's a very strong position to be in if the facts are on your side. And that's largely within your control. If you make good choices, good acts, good decisions, which is hard to do in the stress of a fight, but almost impossible to do if you don't even know where the legal boundaries are at all. Or even worse, like I see in so many people, it's not that there isn't information about self-defense law out there. It's that most of what's out there is wrong, is myth, is just ignorance. I'd rather be judged by 12 than carried by 6. That's a fool's position. First of all, those aren't the choices. Second of all, have you seen the 12? Have you seen a jury, what they look like and how they can be manipulated in the courtroom? You can't just throw yourselves on the mercy of 12 anonymous people whose ignorance and interests may not be aligned with your interests. Okay, so here we go. The judge is playing. Here's the judge. Let's see. Here's the volume.
Okay, so good morning.
Sorry, I'm playing a little. Oh, it's virtual. All right, we're starting with the defense motion to exclude
We
witnesses.
have just one technical issue, which is Mr. Bash has not been allowed into the hearing. If he could be allowed in.
This
Thank
is,
you. I see Mr. Bash has joined.
Alex
Ms.
Spiro,
LeBlanc will be handling that motion
one
on
of the
behalf of
defense
the defense.
counsel.
Thank you, Your Honor. And I will be arguing this first motion.
That's LeBlanc, another defense.
So
Heather
I know that
LeBlanc.
the court has obviously reviewed the motions of the parties. I do want to very briefly, though, put into the record right now for the court the timeline again with respect to various filings that have taken place with respect to this motion, because I do think they are important for the court's consideration. The first is that there was a deadline for witness list disclosure that was issued by the court, and that deadline was May 6th. On May 6th, both the state and the defense filed witness lists that added new witnesses. The state added 8 witnesses and the defense added 9, and this was on the same day. Now, later this same day, the state inexplicably files a motion basically claiming that the defense has untimely disclosed these 9 witnesses and that we have been engaging in sandbagging by adding these 9 additional witnesses, again, keeping in mind that they had just added 8 of their own on the same day. Now, the defense does not reciprocate. We don't file any motions claiming that they've been sandbagging or that they've done anything improper, because both parties have in fact complied with the court's order and filed their motions by May 6th. Now, on May 21st, we respond and we point out the absurdity of the state's position and of their request. On May 31st, which is a Friday, the state files a reply. And in their reply, they are still calling for exclusion of our 9 witnesses who we listed on the deadline of May 6th. Now, at 6:52 p.m. on May 31st, that Friday, the state also files a notice of completion of briefing, which is basically informing the court that the matter is ready to be heard. There's no withdrawal of the motion. They are still maintaining their position and their request that our 9 witnesses should be excluded, the ones that we filed on May 9th. Now, at this point, the defense is aware that we have 8 days that were scheduled for trial. And with 8 days scheduled for trial, the state at this point has listed nearly 50 witnesses, and the defense had 26 that were listed on our list as well. Now, we know that there's no way that we could get through 76 witnesses in 8 days. It's not possible. And so trial is fast approaching, and so the defense recognizes we need to start preparing for trial. We need to start putting these resources where they need to go and be working toward trial rather than investigation. We have to switch gears. So acting in good faith and knowing the state's position with these motions that we've now filed and briefed over the course of the past month, the defense reviews the case and then makes a strategic decision that we can cut down our witness list significantly. And we proceed to file on Sunday, which was June 2nd, a written notice that we are withdrawing nearly half of our witness list. And so we consent to an exclusion of 5 of the 9 witnesses that the state has requested be excluded through their motion. And so we send a courtesy copy to the state of our notice of our intent to withdraw those witnesses. And we also send a new witness list to the state. Less than 3 hours after we sent those copies to the state, after the state now has this insight into defense strategy, and while the state had just hours before still been standing on their motion that our witnesses should be excluded, the state turns around and less than 3 hours later files an amended witness list, adding witnesses that they still have a pending motion to exclude. That motion is still pending, and yet they file an amended witness list adding witnesses that they are still seeking to exclude per their motion. The next morning, then, the state files a notice that they are withdrawing their motion. All of a sudden, there's no prejudice. All is well. All of these things that the state had declared to the court that they would suffer as prejudice by the defense's disclosure of these witnesses on May 6th is now no more. And in fact, they want to go ahead and add some of the witnesses to their own witness list. So we find ourselves, Your Honor, in the absurd position where the state has sought exclusion of witnesses by motion. And this is not through discussion. This wasn't correspondence through emails, through phone conversations where the state says, we think you should pull these witnesses. This is through motion practice. They have represented their position to the court, and they've represented their position to the defense. And they've notified the court, this matter is now ready to be heard because it is completely briefed. And yet within mere hours of getting a look at the defense strategy, the state tries to walk back their motion. Now, obviously, there are rules of criminal procedure that are in place. There are criminal procedure rules that govern time for filing, that govern various procedures throughout this process. And these rules presume that the parties will operate in good faith. They assume, in particular, that the prosecutors will follow their ethical duty, which is to seek justice rather than to simply secure a conviction at all costs. But however, there are times when rules are not sufficient, where perhaps the party is manipulating the court system. And in those times, the court has to look to other doctrines in order to ensure the integrity of the judicial system. And so we look for evidence of manipulation in the court system. And we can do that by looking at the first filing that the state had, where they moved to exclude the witnesses in this case. And in their motion to exclude, again, which was filed on May 6th, the same day that both parties filed their additional witness lists, the state lists out in details the prejudice that they will suffer. They say, even though we filed by the deadline, they point out to the court, there's only 8 weeks. We're only 8 weeks away from trial. The defense, by adding these additional witnesses, they don't have time to investigate this case. And so the defense is engaging in improper tactic, and we're sandbagging the state. The state is prejudiced. These are their words. These are their terms. They also note in their motion and make really what are patently false statements. And what they say is that the state has, at this point, by May 6th, has made all of its witnesses available to the defense for pretrial interviews. That is false. That is not correct. In fact, we had the state's expert witnesses, multiple expert witnesses were actually scheduled to be interviewed after May 6th and were subsequently interviewed into late May. And then even more recently into June based on some new disclosures that have been had. And so that we had not interviewed all of the state's witnesses despite the representation in the state's motion. In addition, the state also told the court and asserted that pursuant to Rule 5501, the state not only disclosed its witnesses, but also has provided the defense with all witness statements and experts' reports, as well as underlying data and a summary of proposed expert opinions. That is also false, Your Honor, because, and the court will see through different motions that are going to be presented before the court, some of which will come before the court today, and others which we will be submitting to the court later. In fact, that is not true. We had not received numerous expert witness supplemental reports. Those had been withheld from us, including one that was particularly exculpatory by Lucian Haig. That had not been provided to the defense as of the May 6th filing of this motion. There were also statements by the state's other expert, Brian Carpenter, that had not been provided to the defense. And to this date, we have, as of this day, we have made numerous requests of the state that they provide these statements that have been redacted through an IPRA request that we had done to try to get a hold of different statements from various witnesses and things like that, communications with the state. And so we are in possession of some emails, for example, email correspondence that does indicate that there are opinions of the state's witness, Brian Carpenter, and yet those have been provided to us in a redacted format through IPRA. So we do not have the ability to see the contents of these statements, but we can see that they exist.
So what's going on here? Right now, she's just gone off the rails because they had an actual complaint here. And now she's saying, not only that, Your Honor, but they're doing all the state's doing all these other things that we don't like. So let me rewind it back to what's supposed to be the actual argument here. The actual argument is that the state and the defense, on the last day that they were permitted to notify opposing counsel of witnesses that they wanted on their witness list, the defense added 8 or 9 witnesses. And of course, you do this on Friday afternoon of the last day, the deadline to notify, for strategic purposes. Then after the defense interviewed some of these 8 or 9 witnesses, they discovered that 5 of them, when they're cross-examined, when they're interviewed by the state, they're going to reveal information that's harmful to our client. They didn't like that. Now, when they did file these witnesses on the last day, on the deadline, the state immediately filed a motion with the court. We reserve the right to exclude these witnesses. We feel we've been sandbagged because they were added at the last minute. The defense has known about these witnesses for months. This was done at the last minute for strategic purposes in a way that's unfair to us. Now, that's just a motion. That's a request from the state to the court to say, hey, we'd like to reserve the right to make this argument to the court and maybe get these witnesses excluded if the court agrees. That would be normal. It's like if you had a bunch of shipments coming to your home and they're furniture. You're having a bunch of furniture shipped to your home. And sometimes when you open up those boxes, the furniture's broken inside. So you got to open up the box and inspect it. But in this case, they deliver it on a Friday afternoon and you're catching a flight for a vacation with your family. So you can't open them up right then. You don't have time. They've been delivered. You've been notified. You're there when they bring the boxes, but you don't have time to open up the boxes and see if there's anything objectionable. So instead of signing the delivery receipt, the packing slip, and saying everything's okay, this is fine, you sign it, you say, but I reserve the right to inspect these packages when I get back from my trip to determine if anything's broken. That's essentially what the state did here. The defense said, hey, last minute, 9 more witnesses. We're just notifying you now for the first time. The state said, we're filing a motion reserving our right to ask the court to exclude these witnesses because we believe we were sandbagged. Of course, they put it in more technical legal terms. It doesn't mean the witnesses have to be excluded. The state could, you could open up those boxes and find the furniture's undamaged. And then you say, all right, that's fine. We'll keep the furniture. Or you open up the boxes and you find the furniture's damaged and you say, no, we reserve the right to inspect afterwards. We're shipping this broken furniture back. That was the state's position. Well, what happened was the state filed that motion reserving the right to exclude these last-minute witnesses. And after that, the defense realized that half of these last-minute witnesses were going to be damaging to the defense. They were like, oh, crap. You know what? We're going to pretend, we're going to act like we're agreeing with the state out of the kindness of our hearts for the efficiency of the trial process. We're going to say, you know what, Your Honor, that's fine. We understand the state has an objection to all those last minute witnesses. We're going to take 5 of them off the calendar, off the list. Of course, it's the 5 that are damaging to the defense. And they're pretending they're doing it as a favor to the court and a favor to the prosecution, which is obviously not the case. Well, the prosecution sees them do this. And this is before the court has made a decision on the motion to exclude, before the court has made a decision that these witnesses are off the list. It's still pending, this motion. The state sees the defense withdrawing their own witnesses, and there's only one interpretation to make of that, right? And that is that, well, the only reason the defense would withdraw its own witnesses, maybe they're doing it out of the kindness of their heart. Or maybe they're doing it because they realize these witnesses are damaging. So the state says, nope, we want those witnesses now. We want them. We withdraw our motion to exclude with respect to those witnesses. That's what's being argued now. And now the defense is saying, Your Honor, that's not fair. That's not fair. That's what's really going on.
Now, there are many, many of these documents, and we don't know fully what might be.
Oh, now she's transitioned to a completely different topic. It's not even in the motion. Now, instead of talking about, and this is just because she recognizes she doesn't have a strong argument on the, if she focuses on the legal question here, should these witnesses be excluded or not, over the state's objections, she probably feels she's going to lose. So she's throwing in a lot of other stuff. And Your Honor, it's almost like a, sorry, ladies, but gentlemen, if you've ever had an argument with your wife and maybe she's mad about X, and so you start arguing about X, and it turns out you have a pretty good defense. You have a pretty good explanation for why you didn't take the garbage out right away. Like your leg was on fire. You had to put the fire on your leg out first. Then you were going to take out the garbage. Sometimes a wife might see she's losing on that argument X, so she just transitions to Y and then to Z, and then starts at the top of the list with A, B, C, and D that happened 15 years ago. I'm sure many of the husbands out there have had this experience. That's what Heather LeBlanc is doing here. She's like, and by the way, Your Honor, but besides this whole witness thing, the state's been mean to us in other ways. They haven't given us this or haven't given us that. Maybe there's merit to those arguments, but then they should be separate motions, not part of the motion to exclude witnesses.
Be contained within these various email communications and correspondences between the state and their expert witness. And we've asked the state, in compliance with their affirmative duty to provide statements of their witnesses and statements of their experts and opinions of their experts to the defense, we've asked them to provide.
I see a comment here from a Glenn. I guess this is a YouTube comment, which normally I don't read, but this one is funny. He says, keep in mind that Andrew's biased as hell, and there is nobody to challenge his spin. Were defense counsel to have a chance to rebut, you would not be as impressed. Glenn, this is defense counsel. I'm showing you defense counsel. This is their argument. They're making it.
Unredacted copies. And the response has been, you have to go ahead and identify for us which ones it is you need unredacted, and then we'll take a look at it. That's not how this rule works, Your Honor. The rule works that the state has a duty. They have a duty to go and look for and to exercise reasonable diligence to uncover statements and opinions of witnesses and expert witnesses, and they have an affirmative duty to provide those to the defense. And yet they're putting that burden again on the defense. We have also had disclosed to us over 150,000 pages of other documents. We had, as late as May 23rd, audio recordings that were taken by the state's investigator, Connor Rice, of various witnesses whom the state had listed on its witness list.
None of this has anything to do with the defendant's expedited motion to exclude witnesses.
That we had never been provided, and we only received them on May 23rd. And the list goes on, Your Honor. It includes then the state has now filed, as the court is aware, is pursuing use immunity for Halyna Gutierrez Reed.
This use immunity is next. That's going to be argued in a separate motion next. It's not part of this motion. The fact that she can't focus on the legal core of this motion, defendant's expedited motion for use immunity, that she's bringing in all this ancillary stuff that either is not on the docket for discussion today at all, would require completely different motions and argument, or that she's bringing into the first half hour of the day motions and arguments that are scheduled to be made later in the day, tells you all you need to know about her confidence in her core argument about excluding the witnesses.
And in accordance with that, they have now provided over 361 recordings for our review based on statements that were made by Ms. Gutierrez Reed. Now,
so this is another funny thing. The defense complains about all these like recordings of things that Halyna Gutierrez Reed said. Most of these recordings were said like during her investigation, her interrogation by police in 2021. 2.5 years ago. The defense has been aware of these. So they're acting like they're ambushed. They were not ambushed.
The list goes on. There's more. There's more that has been disclosed and that continues to come. But these statements that the state has made in their motion as officers of the court are not true. These are factually not true.
Your Honor, the state's a big fat liar. Which they might be, but that's a separate motion.
And so we are prejudiced. And this is why the doctrine of judicial estoppel would come into play, because this court needs to protect the integrity of the judicial process and prevent manipulation of the court system. And so when the court looks at judicial estoppel, it's a three-pronged test. The first two of which are part of the main test, if you will, and the third, while not necessary, is actually a part of the test that indicates that judicial estoppel is even more appropriate if that third prong is met. And so I'll go through those with the court now. The first is that the party against...
I see another YouTube comment. Sorry, folks. It's normally I don't address the YouTube comments, but when they're exceptionally good, I will. Texas Dave says, Andrew, would you defend Baldwin in court? Don't think there's much to defend of this dirtbag. Thanks for bringing this to us, sir. Much respect. Of course, I would defend Alec Baldwin in court. That's the job of criminal defense counsel. As a criminal defense attorney, you don't have a thick client list of innocent clients, folks. Most of your clients are criminals. The question isn't whether is a criminal defense attorney willing to defend a criminal. The question is a criminal defense attorney willing to compel the state to do its job and prove that defendant guilty beyond a reasonable doubt? I'm more than happy to compel the state to do that for any client, even if I don't personally like the client. Personal like has nothing to do with it.
Whom the doctrine is to be used must have successfully assumed a position during the course of litigation. The second is that the first position must be necessarily inconsistent with the position the party later takes in the proceedings. And then finally, while not an absolute requirement, judicial estoppel will be especially applicable when the party's change of position prejudices a party who had acquiesced in the former position.
So, okay. So nothing in their motion to exclude witnesses that I recall made any reference to judicial estoppel, but estoppel is such an odd word. I feel like I should address it. So estoppel basically means that opposing counsel took one position and you relied on that position, and then they changed their mind. And your reliance and their changing of their mind unfairly prejudices you. And a normal word scenario illustrating this might be you work for a company. The company requires you to request vacation time months ahead, right? Not uncommon in big companies. So in the winter, you request 2 weeks off for vacation in the summer. And the company says, yes, we will put that on the calendar. We're granting you that 2 weeks vacation in the summer months from now. And in the interval, you expend a lot of money and resources planning and scheduling and reserving that vacation. Say you're going to Disney World in Florida and you're getting the VIP tour. So it's 10 grand just for the tour and the flights and all the other stuff that's going on. So you spend a lot of money in reliance on the company's informing you that they're going to allocate those 2 weeks of vacation to you. And then a month before your vacation, long after any period to get a refund on any of these expenses for your vacation, the company says, you know what, we change our mind. You can't have that vacation after all. That would be a circumstance where you would argue in a legal sense, estoppel. Essentially, no, I asked you and you told me I could take the vacation. And now I relied on that, incurred a lot of expenses, and now you're reversing that decision. You should be stopped from reversing that position. That's what estoppel means. Here, they're essentially saying that the court should exercise estoppel because we had witnesses on our list. The state said we reserve the right to exclude those witnesses. So we agreed to withdraw the witnesses that were harmful to us. And in doing that, we no longer have time to finish preparing those witnesses. And therefore, the state should be stopped from wanting those witnesses, from withdrawing its motion to exclude those witnesses. Detrimental reliance is another good way of putting the estoppel concept.
And so we'll start with the first prong. With respect to the first prong, Your Honor, the state has successfully assumed a position. The state took a position in a motion that witnesses should be excluded, and the defense, after full briefing of the case and in reliance on that position, the defense then conceded the state's the relief that the state had sought as to 5 of the 9 witnesses.
At least we're back on point. And these are the 5 of the 9 witnesses the defense had realized after adding them to their witness list on the last day, the deadline day, these 5 were going to be harmful to the defense.
That the state was looking to have excluded. So the state was successful. In its motion, the state tries to indicate that that in fact, a party must have already had the matter adjudicated by the court in order for there to be a successful position that was taken by the court. I'm going to go to the state's motion. And so what the state says is that this must have already been adjudicated by the court in some way through some order by the court. There have been no arguments, is what the state says. The state says the record in this case is crystal clear. There were never any hearings or other judicial proceedings in which the state's initial motion to exclude certain defenses was adjudicated by the court. And therefore, their position is that that means that there was no, that we don't meet the first prong. However, that's incorrect, Your Honor. And if the court will look at the case that we cited, and it's Kuchan, which is a 2024.
I'll mention once more that we do address all comments and questions from our law self-defense members for free in the member chat. If you're on YouTube and you'd like a question or comment mentioned, if it's exceptionally good, I might do it for free. If it's just repetitive or tiresome, like Glenn has become in the YouTube channel, I'll address questions and comments in YouTube. I promise to do them if they're at least a $10 super chat. So Glenn, if you want me to address any of your tiresome comments, they need to be $10 super chats. And if anyone else does a $10 super chat, I'll address their comments as well.
Or case. The site is 2024 NMCA 032. And when we look at this case in paragraph 14, the court notes that the respondent in that case did not successfully argue and therefore assume this position in a motion or at hearing. So the use of the word "or" clearly demonstrates that a party can assume a position either by its argument through a motion or also by its argument at a hearing. So it's either or. It doesn't have to be at a hearing. It can also take a position through argument in a motion.
Sorry, folks. I do want to address this. So I guess we have some new law self-defense members joining, which is great. You can become a new law self-defense member right there for 99 cents. lawofselfdefense.com/99 cents. But someone's asking, how do they get to the live stream from the member dashboard? So when you go to lawofselfdefense.com, in fact, let me share it. Like so. This is what you'll see. You'll need to log in as a new member. You'll have your login credentials emailed to you when you become a member. You want to go to dashboard on the left here, upper left. And then depending on, most of you will have become a standard member. So you click standard membership, scroll down, it'll say live, show, and chat. And you'll see the live stream there and the chat below. So now we're piercing the fourth wall here. And that's the chat. So that's what you'll want to do there. All right, let me pull up the, oh, where'd I go with the live stream? So I don't know why the stream is acting weird for me today. It's not doing the full screen correctly. Let's do it like this.
And this is further solidified through paragraph 16 of the same case. In paragraph 16, the court continues and states that the respondent could not be considered to have successfully assumed a position about the nature of the West Track until filing the motion for partial summary judgment. It doesn't say until argument of the motion. It says that upon filing of the motion for partial summary judgment, that is the moment at which the respondent could be considered to have successfully assumed a position. And that is what the state did in this case. They assumed a position in the motion that they filed, both the primary motion and then also their responsive briefing. They assumed a motion, or I'm sorry, they assumed a position. And they successfully assumed that position because the relief that they sought was granted effectively by the defense consent to that relief. The second prong, Your Honor, has, and I will actually point out the cases that the state cited for this principle. So that was the one that the defense cited. The state cited 3 cases in support of their proposal that that a motion has to be argued before the court and there has to be an order in order for there to be a successful assumption of a position. They cite O'Brien, they cite the Gabriel Vigil case, and then they cite a 2014 unpublished opinion, which is non-precedential. So I'll go over the 2 cases that are actually published case law. For O'Brien, in this case, this is a case where the court did apply judicial estoppel. And there did happen to be an order that was entered by the court. It was a pretrial order, but merely finding a case where estoppel was applied and where the court had entered an order does not indicate that the first prong can only be met where the court has entered an order, and that is not the holding of the case. It just so happened to be that in that case, there was an order that had been entered by the court, and therefore that met that part of the prong in the either or. So either in a motion or at a hearing. And so in this case, there was a hearing.
By the way, this part's very fair here. This is why criminal courts are an adversarial process. The state cited some appellate court decision, case law, as authoritative law for its position, and the defense gets to distinguish that decision, both in terms of what the state claims the decision actually means, which can be different from whatever procedure was followed, as well as distinguish from the facts of this particular case, New Mexico versus Baldwin. So each side will find things like case law that they believe supports its position, build it into its arguments, and then the other party, opposing counsel, gets to attack the use of that case. And this is perfectly appropriate, exactly what she should be doing here.
Hearing that was appropriate, but that does not say anything about the fact that one can also take a position through a motion. The Gabriel Vigil case, this one doesn't even deal with judicial estoppel. It actually involved the doctrine of collateral estoppel, which is a different doctrine. So collateral estoppel has a different test than judicial estoppel. And the purpose of collateral estoppel is to promote judicial efficiency and consistency. And the goal is basically to keep parties from relitigating issues from a previous suit. With judicial estoppel, we're talking about a purpose that has to do with protecting the integrity of the judicial process by preventing.
So to clarify here, my editors get mad when I leave myself small in the corner like that. So we talked about judicial estoppel before, right? Someone takes one position, you rely on that position, and then they change their mind, and that damages you, harms you in some way. So you argue they should not be permitted to change their mind. That's what is being argued here. Collateral estoppel is a little different. Collateral estoppel is where imagine, for example, that in the Halyna Hutchins case, the prosecutors had argued that the armorer was the one holding the gun and fired the bullet into Halyna Hutchins. That the gun was not in Alec Baldwin's hand. It was in Halyna Hutchins' hand. And they convict Halyna Hutchins of involuntary manslaughter on the fact basis that she was the one holding and recklessly manipulating the gun, She was the one who didn't check that the gun was loaded, pointed it directly at Halyna Hutchins, manipulated the hammer and trigger, and recklessly discharged that bullet fatally into Halyna Hutchins, committing involuntary manslaughter. And they secured a conviction of Halyna Gutierrez on that basis. Well, only one person could have been holding the gun when it went off and killed Halyna Gutierrez. If the prosecutor argued it was Halyna Gutierrez secured her conviction, collateral estoppel would prevent them from then also claiming that the gun was actually in Alec Baldwin's hand. It was he who fired the gun. But collateral estoppel obviously is not at play here. Halyna Gutierrez was convicted of involuntary manslaughter for recklessness independent of the manipulation of the gun when it discharged into Halyna Hutchins.
Preventing the parties from, and this is quotes from the various cases, from playing fast and loose with the court and ensuring that the party does not manipulate the judicial system. So in light of the fact that there is a 2024 case, which is the case that the defense cited, that precisely states that a party can assume a position pursuant to the first prong through motion alone, the question again is whether or not they were successful, and we submit to the court that they were. Now moving on to the second prong. The second prong says that the first position is necessarily inconsistent with the position that they take later. Clearly that is the case. Clearly that has been met. The state was first saying that there was prejudice by the inclusion of these additional witnesses on the defense witness list. The state's position was that those witnesses should be excluded. And now they have taken the exact opposite position, saying these witnesses should be able to be called by the state and there is no prejudice by their inclusion. Now, even though only the two prongs are actually required, the third prong again indicates that if the party's change of position prejudices the party who had acquiesced in the former position, then judicial estoppel will be especially applicable. And that is the case here. So the defense relied on the state's motion, which the state had told the court on May 31st in their notice of completion of briefing was fully briefed and was ready to be heard. And in recognition of that fact, and recognizing that we are scheduled for trial for 8 days, in an attempt to pare down our witness list substantially, we removed, again, almost half of the witnesses from our witness list, revealing significant defense strategy. And we also informed our witnesses. There were some witnesses who were scheduled to be interviewed the following day, and then a couple of days later. We informed those witnesses that they were released from their subpoenas, and we did in fact release them from the subpoenas, and we told them that those interviews would be canceled.
By the way, the state, so there's a deadline for these kinds of interviews, just like there's a deadline for the adding people to the witness list. The state has said that, hey, listen, we're happy to waive the deadline for the interviews. So if you need more time for the interviews, you've got it. Which rather neuters this particular complaint that we ran out of time to interview people before the deadline.
We sent, again, courtesy copies of our notice to the state along with our amended witness list. And then that's when, within less than 3 hours after seeing defense strategy, the state changed its position. Now, the state proposes that really they can just cure any prejudice to the defense by extending deadlines.
Like I said.
But that doesn't cure our prejudice for a variety of reasons. Primarily, because you cannot cure the fact that we have already revealed defense strategy in reliance on the state's position, and the state has now walked that back. We cannot cure that. In addition, we're in a time crunch at this point, Your Honor, and we do not have further time available. The state, in their motion on May 6th, noted that that they were prejudiced by the fact that there was only 8 weeks prior to trial. We are now in the position where we only have 2 prior to trial. We did not receive significant information from the state previously, and the reason that that is relevant here in particular is because time is a finite resource. The recordings alone that were disclosed related to Halyna Gutierrez Reed are so significant and substantial that if we take an average of the time that it would take to listen to each of the calls, and we dedicated one whole person doing nothing else, taking no breaks for a full 8-hour day, it would take that person approximately 15 business days to listen to the recordings. But we don't have 15 business days, we have 10. And not only that, we also then have to look at the potential of having to interview Ms. Gutierrez-Reed. So time at this point, Your Honor, is a finite resource, and the state is playing games to exploit that resource and to take time away from the defense where we should be spending our time in trial preparation. Instead, we are having to deal with the state's constantly changing positions, with their changing disclosures, with the new things that they're adding, and it's fundamentally unfair. And as the state notes in the state's own words, calculated sandbagging is not appropriate. And what they say in their own motion is that they say this kind of manipulation of the courts should not be permitted, and we agree. And so we are asking the court to therefore exclude the witnesses and to grant the defense motion.
All right, Carrie Morrissey or the new prosecutor? Who's going to take the state's
I have a
side?
couple of questions before I hear from the state. First, you talked about that you had to that you decided.
By the way, previous oral arguments before this judge on cases where I thought the defense was really making a specious argument, and the last one I think we covered was the defense motion to dismiss the indictment for failure to state a criminal offense. The judge was really hard in asking questions of the state. Based on that oral argument, I thought the judge might very well rule for the defense and dismiss the indictment. But she didn't. When she actually wrote her order, it was the order was consistent with the state's arguments, not the defense arguments. So this judge can be pretty tough in oral arguments and arguably a little bit misleading in terms of our expectation of how she might ultimately come down.
Decided that you were going to limit your witness list, cut it down because you had to switch gears for trial preparation. The time for investigation was superseded by preparation. If I'm misstating that, tell me right now.
No, Your Honor, that's correct. That is a big part of the consideration as well, which is why we were assessing our case in that moment to determine what needed to be done.
And so you said that you made this strategic decision, and that, but I'm not clear, and that they know what your strategic decision is. Is it anything more than you eliminated a witness?
No, Your Honor, we did not include any additional dialogue with the court or information in the pleadings, but again, we had pared down our witness list to almost half of what it was. And so I think that gives the state a pretty good idea of what we're going to be doing with the case.
No, does it?
Okay. And so then you're talking about this sort of bait and switch is what you're saying, where on May 6th, they had a problem with your witnesses, and then on June 2nd, you took certain ones off, and then on June 2nd, they added 3 of the witnesses that you took off. And I'm not quite sure how that short time frame I know you're arguing a little more than short time frame, but that's quite a short time frame, right?
A short time frame for what? I'm sorry, Your Honor, if the court would
For the
clarify.
for them to have added the 3 witnesses that you deleted.
Correct. Yes, it was a quick turnaround.
Right.
That is correct. Within
And
hours.
how do you explain that they have always added at the end any witnesses called by the defense, and that you had these individuals on?
That's correct, Your Honor. And so it's a different position, I think, than we would be in if, let's say, the state had not filed a motion to exclude. That's the part that changes, I think, the analysis in this case, because at any point, of course, one party or another can remove witnesses from their witness list. We could not add any more witnesses based on the court's order, but we could remove witnesses from our lists. And there was the catch-all of, any witnesses who were listed by the defense or by the state, and that is correct. However, what's different about this particular situation than the typical instance in which a party may just decide to go ahead and remove witnesses is that we did so in advance of the final trial witness list, for example, that this court has, which I believe is Monday. And so we did so in advance of that in order to say, okay, we're not even going to finish doing these other witnesses. We know where our case is going to go. We're pulling these people off, and this is what we're going to do. And we did that in reliance on the briefing that was filed by the state. And so it's a bit of a different position because the state had already effectively indicated to the defense as well that they did not intend to call those witnesses by moving to exclude them. You can't move to exclude witnesses from trial for the defense, but then be keeping them for the state. That's not what they were saying in their motion. So what they were saying was these witnesses should not be called at trial. And so they're saying that they also will not call those witnesses. We then in reliance said, okay, fine, we agree to not call those witnesses. And so this is a different position than one party unilaterally just removing witnesses from their witness list because it was done in reliance on the state's briefing and on their motions.
So the prejudice is, what?
So the
You
prejudice,
went into this whole thing that is not in your, it's more of your Brady violation motion. So what's the prejudice?
so the prejudice at this point, Your Honor, is we already had canceled and released witnesses from subpoenas. So they were no longer valid subpoenas since we had already informed the witnesses that they no longer had to be there. The witnesses, even though some of them had already been interviewed, the problem is, and again, we don't want to go through an analysis of what each of the witnesses would be because we're not going to reveal further strategy to the state than we already have. And so we're not going to do an analysis piece by piece, to tell them what the import is or is not of each of the witnesses.
That's not
But
an
suffice
argument.
it to say that we did an analysis of these cases as a group, as a whole, could be released and could be removed from our witness list together. If only some of them are now coming back, then that can again impact whether or not there need to be other witnesses who would still remain on the list whom we have not interviewed. And the state says, we can just extend the deadline, right? We can extend the deadline to take care of that issue. That's the state's proposal. But again, we have a finite amount of time and we are in full trial prep mode at this point. And so that's the prejudice, Your Honor.
That you can't interview 3 more witnesses because you might have to interview some additional ones.
And that's the thing is we made a decision and a call based on whether or not we might need additional witnesses. That's correct.
Very weak.
Beyond that, but at this point, we don't have the ability to do that, and so that's the prejudice.
So the prejudice is that you're preparing for trial and you can't do these pretrial interviews. I'm trying to, you need to articulate it for me.
Of course, absolutely, Your Honor. So that is certainly a part of the prejudice. And so it's multifaceted. So that is a part of the prejudice. The other part of the prejudice that is specifically related to the witnesses is
This is the judge just taking a fan and blowing away the smoke from all this argument, getting down to the gist, the nugget of what the defense argument is supposed to be. And it's not very strong.
Releasing or removing nearly half of our witness list. We also, again, some of these witnesses are interconnected. And so now we have removed 11 witnesses and the state is now adding back piecemeal, which witnesses they want to put on. And it happens to be some of the ones that they had moved to exclude. Those are the ones who they've listed as being added. And so the prejudice is that it does impact our case and our presentation.
And then your judicial estoppel is talking about fast and loose, but you're also that, they took one position and then they took another position, but you're talking about all in the same, I don't know, what is it? 48-hour period. They added them and then did their withdrawal. And you're talking about that constituting judicial estoppel?
Yes, Your Honor, because it wasn't just that one moment either. It was the fact that this had been briefed over the course of a month as well. And the state had indicated that the briefing was completed. And these witnesses In particular, they were very difficult for us to serve as well. We don't know that we would be able to get them back. We had difficulty serving them through our process servers,
Weak
and they were hard
sauce.
to find. And then there was also one who was released who was actually an out-of-state subpoena witness. And those also take additional time that we don't have.
Would you
at this
try?
Appreciate it. Thank you.
Yes.
I don't know who's going to be arguing.
It's me, Your Honor.
Okay.
Thank you. May it please the court. Your Honor, the case that
It's the
actually governs
Erlinda
this court's
Johnson.
analysis is State versus Harper. And in State versus Harper, the court,
So, Erlinda Johnson, a late addition to the special prosecution team. So, Carrie Morrissey was a career defense attorney. Here we go. So, Special Prosecutor Carrie Morrissey, career defense attorney, appointed as a special prosecutor to prosecute the Rust cases for various reasons. The elected prosecutor in the district didn't want to do it for reasons that don't really matter. Carrie Morrissey was appointed after well, doesn't matter. She was appointed special prosecutor for these cases. She prosecuted Halyna Hutchins. She worked out the appeal deal for First Assistant Director David Halls, and now she's prosecuting Alec Baldwin. But she did begin to run into a little, what seemed to me, some difficulty in dealing with the Alec Baldwin defense team. These lawyers are far better than the Halyna Hutchins defense lawyer, who was working by himself. Alec Baldwin retained a bunch of high-level Manhattan lawyers. Their firm is Emanuel Quinn. It's one of the top 50 law firms in the world. The top guys here, Alex Spiro and I forget the second gentleman's name, both partners. They generally do commercial litigation, but they'll be super smart guys, no question about it. And they've also brought on a team of, including Heather LeBlanc, who we've just heard arguing, a team of 7 or 8 other attorneys, all outside of New Mexico. They have one local attorney who's the local New Mexico attorney. Maybe that is Heather LeBlanc is the local attorney. The others are all admitted pro hac vici. They're not admitted to practice law. Generally in New Mexico, they're mostly New York lawyers and a few from other states, branch offices of Emanuel Quinn. They've been admitted to practice for the purposes of this trial by the trial judge under the umbrella of the local New Mexico defense attorney. And they've been filing lots of motions, making lots of very creative, even if I think many of them are specious, but many creative defense arguments. And it wasn't hard to imagine that Carrie Morrissey, Special Prosecutor Carrie Morrissey, was getting overwhelmed. So after the Halyna Hutchins trial, but before, obviously now, she brought on Erlinda Johnson, this woman on the screen here, who is not a career defense attorney, who suddenly finds herself as a prosecutor. She's a career prosecutor. And she's part of the team here. And she's going to make now the counter argument on behalf of the state as to why these witnesses, initially offered by the defense and then abruptly withdrawn, should be allowed to testify at the trial and should not be excluded. So that's the Erlinda Johnson story. This is the first time I've seen her argue. So this will be interesting. The big question, of course, is does she own a hairbrush? It doesn't look like it. We'll see. Yeah, pro hac vici is a process by which an out-of-state attorney can be admitted to act as counsel in a particular proceeding with the permission of the judge. Generally, you also need a local lawyer there on the team who's familiar with local rules and procedures and so forth. It's not, I wouldn't say it's common, but it's not super uncommon either.
New Mexico Supreme Court at 211 New Mexico Supreme Court 44 paragraph 2 noted that exclusion of witnesses requires an intentional violation of a court order, prejudice to the opposing party, and consideration of less severe sanctions. And when considering sanctions, prejudice to the opposing party is a central consideration. And in Harper, at paragraph 19, the Supreme Court noted that even when a party has acted with a high degree of culpability, the severe sanctions of dismissal or exclusion of key witnesses are only proper when the opposing party has suffered tangible prejudice. And in this case, Your Honor, first, I would submit to the court that prosecutorial discretion allows the prosecution to make decisions with regard to the evidence plans to present at trial. Unless bad faith is demonstrated, those decisions are generally not subject to review. I would submit to the court that in this case, what happened, Your Honor, is that on May 6th, there were a number of witnesses disclosed. Because that was the pretrial motions deadline, the state had no idea the defense was planning to call these witnesses. So we filed this motion. But then these witnesses were set for pretrial interviews, the ones that the defense now seeks to exclude. These witnesses were interviewed. These witnesses, then the state investigated the statements of these witnesses and determined over a period of that weekend that it would be there would be no prejudice to the state. So we went ahead and withdrew the motion. And so what's important for the court to know, Your Honor, is that Mr. Zach Sneesby, which is one of the witnesses that the defense fortuitously decided to withdraw, actually was interviewed the week before the last week in May. And during his interview, he revealed that he was standing very close to Mr. Baldwin when he shot and killed Halyna Hutchins. And Mr. Sneesby specifically said he saw Mr. Baldwin pull the trigger. And as you know, the defense position has always been that he didn't pull the trigger. Well, now there's an eyewitness who actually says he saw him pull the trigger. And he said this during his pretrial interview. The state conducted additional investigation and determined that it would then withdraw its objection or opposition to these witnesses. There was no bait and switch. There was no bad faith. And what's important, Your Honor, is that these were...
So bad faith might be if the state changed its position. What happened? Okay, sorry, folks, I got confused. I have too many tabs open. Bad faith might be where the state changed its position in the absence of any new information for strategic purposes or to ambush the defense or something along those lines. Here, the state's saying, yeah, we changed our position because we got new information. We learned from his interview that this witness is prepared to testify that he saw Alec Baldwin press the trigger when Baldwin discharged that bullet into Halyna Hutchins. And the defense has been arguing throughout that the gun went off by itself. Alec Baldwin has said repeatedly he never touched the trigger. That's relevant to an issue in dispute in this case. So that's not bad faith. That's good faith.
Defense witnesses. It's not like these were state witnesses that were not made available for pretrial interviews. These were defense witnesses. Presumably, the defense had spoken to them, had investigated what they were going to say, and they disclosed them on their witness list. So for them to now argue prejudice is, I would respectfully submit, disingenuous, because they are seeking to exclude and claiming prejudice because they withdrew and didn't have time to set up pretrial interviews of their own witnesses. Well, if we're going to list witnesses on our witness list, we first interview them, find out what they have to say, and then we list them on our witness list if we believe their information or the evidence they're going to present is relevant. On May 6th of this year, the state filed its witness list. The 45th witness, as the court noted, is any witness disclosed by defense, called as a witness by the defense, or listed on the defense witness list. The fact that the state then listed the witnesses the defense sought to withdraw on its witness list does not result in a violation of the rule, because we did, as the court pointed out, the 45th witness was any witness listed or disclosed by the defense. Your Honor, with regard to the prejudice, because before the court can impose the severe sanction of exclusion, the court has to find that there is prejudice. At paragraph 19 through 21 of the Harper decision, the court specifically stated, and I quote, "The requirement that any serious sanction against the state be conditioned on a finding of prejudice is well established in our case law. Prejudice must be more than speculative. Therefore, when discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defense preparation for trial." These were defense witnesses, and that bears repeating. These were not state witnesses that the state suddenly disclosed a few weeks before trial. These were their own witnesses that the state put on the witness list on June 2nd. Therefore, Your Honor, under Harper, I would submit to the court that there has been no intentional violation of the court's order. In fact, there has been no violation of the court's order, and therefore the extreme sanction of exclusion is not justified. The state offered and continues to offer. We will agree to extend the pretrial interview deadline. If they wish to interview yet again, potentially their own witnesses, we have no objection to that. We have no objection to extending the pretrial interview deadline. And that would be the appropriate remedy in this case, Your Honor. With regard to the doctrine of judicial estoppel, I would submit to the court, Your Honor, that this is a doctrine that would not be applicable in criminal cases. And we cited to a case that could be analogous for that proposition, and that's State versus Arevalo. And that's 2002 New Mexico Court of Appeals 62 decision, wherein the New Mexico Court of Appeals refused or rejected the application of non-mutual collateral estoppel. And in that case, the New Mexico Court of Appeals, in citing Standifer versus United States, a U.S. Supreme Court decision from 1980, noted that the question whether the contemporary doctrine of non-mutual collateral estoppel basically is an unknown for New Mexico courts. Now, in New Mexico, with regard to criminal cases, the important interest in enforcement of criminal law and the public interest in the accuracy of justice of criminal results are not present in civil litigation. So what the defense is asking this court to do is to apply a doctrine from civil law to a criminal case. And we have different concerns, Your Honor. We have different concerns in a criminal case as we do in a civil case. And so as the court in State versus Arevalo rejected and refused to apply the doctrine of non-mutual collateral estoppel, this court must reject the defense invitation to apply this judicial estoppel doctrine to this criminal case. The state was not able to find any case where the doctrine of judicial estoppel was applied in a criminal case. And that's because, based on Arevalo, the appellate courts in this state would likely reject the application of that civil doctrine to a criminal case. But assume even if the court were to consider applying judicial estoppel, the state respectfully submits, Your Honor, that the defense has failed to meet the requirements. First, the party against whom the doctrine is to be used must have successfully assumed a position during the course of litigation. Now, the defense argues that there need not be a judicial decision. The state submits to the court that that is a prerequisite. And even the case that they cite to matter of state of Kuchan, at paragraph 14, the court specifically says, quote, under New Mexico law, a party successfully assumes or argues a position when the party takes that position before a judicial body, that position is at issue, and the party is ultimately successful. The Kuchan court cites to Wooten versus Vinson, and in that case, the court declined to apply judicial estoppel in a dispute over attorney's fees to the plaintiff's argument that the fees were reasonable, in part because the plaintiff did not ultimately convince the district court that her attorney's fees were unreasonable. This court had not yet ruled on the state's motion. So that prong of the judicial estoppel doctrine does not apply in this case. Counsel argues that, well, it's either a motion or have an order and the first prong is met. Given the language from the Kuchan case, the New Mexico courts, appellate courts, would likely find and did find in that case that there has to be some judicial decision as it relates to the position that was taken by the party. But assuming the court finds the first prong is met, I would respectfully submit that the defense has failed to meet the prejudice prong. And the judicial estoppel doctrine requires the defense to establish that they have suffered prejudice. There has been no prejudice in this case. Again, these were defense witnesses who were disclosed by the defense, presumably interviewed by the defense, and that's why they disclosed them, because they obtained information that they believe would be favorable to their position. So there is no prejudice in this case, and we're talking a very short period of time. And again, prosecutors' pretrial decisions carry or enjoy a strong presumption of regularity. Unless there has been a showing of bad faith, those decisions should remain in place, Your Honor. There is no prejudice to the defense as it relates to this particular issue. And as I noted, Your Honor, under Harper, the decision here would be to extend the pretrial interview deadline, allow for the defense to speak to their own witnesses, and any prejudice is cured. And we would respectfully request that the court deny the defendant's motion to exclude these witnesses.
I don't know. We'll get a decision now from
Reply,
the court.
Ms. LeBlanc.
Yes, Your Honor. I'd like to address a couple of the cases that the state has raised. First, with respect to Arevalo, State v. Arevalo. On this case, Your Honor, where they're talking about mutual collateral estoppel. Again, collateral estoppel is a different principle, but what the court was deciding in this case was that.
By the way, this judge, Mary Marlowe Sommer, was just great in the Halyna Hutchins trial. I thought she was awesome. She's very, she's got a very funny demeanor. It's like she's seen it all. She's just waiting for her pension. She's not excited about anything that's going on, but she takes no nonsense, and she's very deliberate and reasoned in her decisions. I like her quite a bit. The judge.
There were two co-defendants, and they each had been assigned separate jury trial settings. At one jury trial setting, one of the co-defendants was found not guilty. Then the co-defendant who was set to go to trial second, then instead filed a motion for judgment of acquittal, asserting that because the other co-defendant was now found not guilty, that the same should apply to him. And so that was what the decision was, and the court, found that there was a lack of mutuality. So this is, a very different analysis than judicial estoppel. There is precedent, however, for the use of civil type doctrines or principles when we look at, for example, specific performance that derives from contract law. And we have cited cases in our motion as well that have to do with the proposition that when the state has made an offer of a plea agreement where the defendant detrimentally relies on that offer, even if it has not been yet accepted by the court, then the state has to engage in specific performance and leave that offer open. So there is precedent, Your Honor, for the inclusion of civil doctrines within the criminal context when it is appropriate. And in this case, it is appropriate in order to maintain the integrity of the judicial process. The other proposition that the state has put forth before the court was that basically criminal prosecutions and their discretion in initiating and conducting those prosecutions will not be disturbed, those decisions by the prosecutors. And for that proposition, they cited Blackledge v. Perry. And in this case that was cited by the state, actually the court did not say that the prosecutorial discretion would stand absent bad faith. They say the opposite. What they said was that even in the absence of bad faith, the state cannot indict on a felony after the defendant had been convicted on a misdemeanor and then appealed the conviction and got a trial de novo. And they said even where there was not bad faith, the prosecution cannot do this because, in fact, they don't want this to have a chilling effect on defendants who would be exercising their right to appeal. And so that is not accurate, that bad faith is the only way in which a prosecutorial discretion can be overturned. And I would ask the court to consider the fact, again, in the state's own words, in their motion that they filed on May 6th, the rules do not contemplate gamesmanship, and this court should not countenance such conduct. I will also point out, as a couple of final points, that the state talks about, the time the defense had to investigate this case. However, the state has had even longer. The state has had nearly 3 years to investigate this case. And somehow within that short window of, less than 48 hours between when the last witness had been interviewed on May 31st, and then the moment that the defense had filed had submitted its courtesy copies and filed its notices of withdrawal of witness and also its new amended witness list. Within that period of time, what changed? What additional investigation was had that didn't already take place before?
The
They had
testimony
told the court nothing about any of
Baldwin's
those
finger was
specifics.
on the trigger.
What changed was that the defense revealed its position, and then they sought to take advantage. And in addition, the state says that they filed its motion to exclude as a placeholder motion. First, in order to file a motion, there has to be good faith. You have to have an actual basis to file a motion. The state in their motion claimed prejudice. That is different than a placeholder motion. If they're saying it's just a placeholder, then how are they making assertions of prejudice if it's just something there? So it sounds like the state is saying that those are just words that they included because that was the standard that they needed to meet, rather than actually determining that they had suffered prejudice because it was merely a placeholder. So we would ask the court again to grant the defense motion. Thank you, Your Honor.
Thank you for your presentations, counsel. The court makes the following ruling, which will be followed up by a written order.
Good.
The court denies the expedited motion for order excluding witnesses. I did not think that the defense has demonstrated the prejudice that is required under State v. Harper. The defense was on notice that the state may call defendant's witnesses through their May 6th witness list addendum. And given this notice, the court does not find that defendant was prejudiced by the later filed June 2nd, 2024 witness list addendum. With respect to the judicial estoppel argument, that also is denied as part of this order because the doctrine is to prevent parties from playing fast and loose with the court by successfully arguing one position and then later adopting a position inconsistent with the first. And there, I don't think you've met the prongs of, first of all, they didn't successfully argue before the court, and also I don't think that there's the prejudice as contemplated by Hutchins. So you'll get. All
right, first battle of the day. Defense motion to exclude witnesses, their own witnesses, one of whom is going to testify that he watched Alec Baldwin press the trigger when the gun in Baldwin's hand discharged and killed Halyna Hutchins. That's a defense witness that the defense suddenly tried to withdraw when this came out, and but now it's a state witness. So first battle of the day by Judge Mary Marlowe Sommer called for the state prosecution of Alec Baldwin. 1-0, state versus defense. All right, let's continue. The second battle of the day will be the state's expedited motion for use immunity. This is the immunity that the state wants to grant Halyna Gutierrez, the armorer already convicted of involuntary manslaughter in the killing of Halyna Hutchins. Her reckless mens rea being the manner in which she failed to keep live ammo off the set and out of the gun handed to Alec Baldwin. She was convicted of involuntary manslaughter at trial a couple of months ago, sentenced to 18 months in prison, serving that sentence now. She is appealing her conviction. Of course, what do we say? Appeals are for losers. Less than a 1%, about 0.6 of 1% chance of meaningful relief on appeal. And I have to be honest, I didn't see any glaring legal errors in her trial that would warrant any kind of reversal on appeal. But theoretically, she could win a new trial on appeal and come back on to trial. So she doesn't want to be compelled to make statements that could be used against her on appeal or in a retrial. And that's why the grant of use immunity. So if you're given immunity for what you're being asked about, then what you answer, use immunity, cannot be used against you in a future proceeding. So there is no incrimination. And if there is no risk of self-incrimination, you can be compelled to testify or held in contempt of court. So the state has filed a motion, a request with this court to grant Halyna Gutierrez use immunity so they can compel her to testify in the trial as a state witness. The defense obviously does not want Halyna Gutierrez to testify because much of what Halyna Gutierrez has to say is harmful to the state. We covered this yesterday when we went over the use immunity motion for Halyna Gutierrez. So that'll be the second argument of this morning. Hopefully the judge is going to give us her decisions in real time like this. That would be great. Sometimes she says, I'll think about it and give you a decision in a week. But this was nice. We heard the first decision on the first battle about the defense being able to suddenly withdraw witnesses has been denied, and the state won on that argument. All right, let's proceed here.
These orders next week. All right, next up. All right, this is the state's expedited opposed motion for use immunity. And
That's me, Your Honor.
all right, Mr. Bowles was trying to get on. No, no, this isn't his.
Well,
So this is Carrie Morrissey, the original special prosecutor, the lead prosecutor of Halyna Gutierrez, who achieved the conviction there. So this motion by Carrie Morrissey, by the state, every time I talk, I should make myself bigger. So this is Carrie Morrissey, the special prosecutor who secured the conviction of Halyna Gutierrez. She's filed the motion for use immunity, that Halyna Gutierrez should be given use immunity so she can be compelled to testify in the Alec Baldwin trial. That motion for immunity is being denied, not being denied, being opposed, not just by the Alec Baldwin defense team, but also by Halyna Gutierrez's own lawyer, Jason Bowles, who apparently is still representing Halyna Gutierrez on appeal. Now, that's a separate issue I should address, I suppose. That's crazy. First of all, he was poor at trial. I know he's got some kind of reputation in New Mexico. And I guess he's if I recall, a veteran of some kind. And thank you, Jason Bowles, for your service. But he was not great in that trial. And he was not great at all in as counsel in the interrogation of Halyna Gutierrez, her second interrogation by police detectives, homicide detectives. Sometimes he was on his phone. Sometimes he was flirting with the two female detectives. I mean, it was kind of embarrassing. And he just let his client talk and talk and talk and talk. That's not what a lawyer is supposed to do. When we say don't talk to the police unless your lawyer's present, it's because we presume your lawyer is going to do something, not just sit there like a lump on a log. But in any case, however good your trial attorney might have been, if you get convicted and you're appealing, you need appellate counsel, not trial counsel. First of all, it's a very different skill set, appellate work rather than trial work. It's a very different skill set. Second of all, one of the arguments you want on an appeal always in your pocket is ineffective assistance of counsel. That, hey, the reason I got convicted is because my trial lawyer sucked. And that's one of the few bases of appeal that do not need to be preserved at trial by an objection. So a lot of potential appeals are lost because the trial counsel didn't object at the time. And if there's no objection, it's not preserved by appeal, and generally the appellate court won't hear it. But if the question is, my lawyer was unconstitutionally ineffective, you have a constitutional right to effective assistance of counsel. If your argument is my counsel was unconstitutionally ineffective, well, then of course he didn't object. He's ineffective. So you don't need an objection to argue that to the appellate court. So that's always a grounds of argument. Now, it's not a very good grounds of argument. The threshold for being ineffective counsel is so high, it's almost never achieved, but you want to be able to make the argument. You can't really make the argument that your trial counsel was ineffective if you're keeping him for your appeal. That doesn't make any sense. So that alone is crazy. It would be fun to see Jason Bowles back arguing in court again. I mean, in this hearing, that would be funny. So apparently, he's trying to get involved in this argument about the use immunity too. To represent his client in this argument.
Well, I was actually wondering why he wasn't on, because he did file a response.
That's
Well,
correct, Your Honor, and I believe the state's reply addressed both defendants' briefings as well.
Well, but there's an issue there because the defendant, Mr. Baldwin, does not have standing to oppose use immunity for Ms. Gutierrez. That's outlined in the case law. I can give you the case. It's State v. Brown.
Okay, I didn't even call this yet. I just mentioned about Mr. Bowles. So let me try to see if staff can get him on now.
So good judge is being a good judge, following procedure. Like I don't want to hear any argument until we do it right. And doing it right means that first it's the state's motion. So first I'll call the state. State, you're up. Let me hear what you have to say. Then I'll call the defense, and then I'll call the state to rebut. That's the process. That's how these things are done. Not just, it's not a cocktail party, not just random arguments being thrown around the courtroom. So she's trying to get Jason Bowles, poor Jason Bowles. Oh my God. If he calls in from a hot tub or something, I am going to LOL. Yeah, this judge is very, very, very sharp, very sharp. And I like her quite a bit. So if I were Halyna Gutierrez, I would definitely, I think, was he ineffective? I don't know, man. When he was in that interrogation, that the second Halyna Gutierrez interrogation, the first interrogation of Halyna Gutierrez by Detective Hancock and the second detective, I forget now who that was. Hancock would ultimately be the lead detective. When Halyna Gutierrez was in her first interrogation, she had no lawyer present. It was the day of the shooting. It was a few hours after Halyna Hutchins had been shot dead. But in the second interrogation, when Halyna Gutierrez got rid of the purple hair and the crappy clothes and shows up in like a sundress and a bow in her hair, I guess Jason Bowles got that right. But when she showed up for that second interrogation with her lawyer, Jason Bowles, in the room, she's in there for like, I forget it, a long time, an hour and a half, 2 hours. And most of the time, he's just sitting there. He's not guiding. I don't remember once him advising his client, don't answer that question.
All right, next up is D1010-2024-13, State of New Mexico versus Alex Ray Baldwin. Again, this is the order denying state's amended opposed expedited motion for use immunity for Halyna Gutierrez, and parties that are arguing, state your name.
Carrie Morrissey on behalf of the state.
Who's hello?
On behalf of the defense, it'll again be briefly Ms. LeBlanc, and I understand Mr. Bowles is on too. So I don't know if the court's waiting to hear from him.
Okay, go ahead, Ms. Morrissey.
So, Your Honor, as an initial matter, the defendant, Mr. Baldwin, has no standing to oppose use immunity of Ms. Gutierrez, and that's laid out in State versus Brown, 126 New Mexico 338. And I imagine that's the reason that their response indicated really that their complaint was that it wasn't timely and didn't really articulate any other objections. And that's because they're aware that they don't have standing to present any other objections. So to kind of back up, Ms. Gutierrez, as the court can see from the pleadings, was initially named on the state's witness list in February. She was then named on the defendant's witness list in April, and I believe she was also named on the defendant's witness list in May. She was scheduled for a pretrial interview after some difficulty, and I personally intervened and set up that interview, even though it was the defendant's responsibility. So we interviewed her, and as the court can see, when we interviewed her, I would certainly argue inappropriately, her attorney
Mr. Bowles.
instructed her to assert her Fifth Amendment privilege to questions that did not trigger.
Just a minute. Is there a reason why the attorneys are not on video? Under our rules, you're required to be on video when we're doing hearings.
I'm sorry, Your Honor, I just kind of lost my train of thought.
So now I lost my train of thought. I was going to make a comment there. Oh, yes. So your Fifth Amendment right not to incriminate yourself. We all have that, right? But it's not a universal privilege to not answer any questions because there are questions that don't carry the potential. Do this again. So your Fifth Amendment right not to incriminate yourself. We all have this. But your Fifth Amendment right not to incriminate yourself is not some universal license to not answer any questions. It's a license, a privilege, a right to not answer questions that may incriminate you. If the answer to the question does not have the potential to incriminate, you're obliged to answer it. If you're under oath in a deposition or testifying at trial, the court can compel you to answer. Now, if it's a question that has the potential to incriminate you, you can assert your Fifth Amendment right. But this can be challenged, and the court can say, well, you need to explain to me in what way this has the potential to incriminate you. And if you don't convince me, I'll compel you to answer. So in the case of Halyna Hutchins, there might be lots of questions about, like, how often what steps did you take to ensure there would not be live ammo on the set? Well, that might incriminate her if the basis of the criminal charge against her is her recklessness in allowing live ammo on the set. But if the questions were, I was going to say, what is your gender? And then I remembered we live in 2024, so who knows? How many feet do you have? And she said, I'm not going to answer that question on the basis of my Fifth Amendment right not to incriminate myself. The court could compel her to answer. How many feet she has nothing to do with any criminal charge against her, any legal liability she's facing. So here Carrie Morrissey is saying, listen, we were asking her all kinds of questions that have nothing to do with her legal liability. They may have a lot to do with Alec Baldwin's legal liability, but you can't claim the Fifth Amendment to protect someone else. You protect the Fifth Amendment to protect yourself. So this is the argument Carrie's making in the moment here.
So she was scheduled for a pretrial interview. We interviewed her. Mr. Bowles instructed Ms. Gutierrez to assert her Fifth Amendment privilege when questions were posed to her that didn't really trigger her Fifth Amendment privilege. The state is not seeking information from Ms. Gutierrez about her criminal conduct. The state is seeking information from Ms. Gutierrez about the criminal conduct of Mr. Baldwin. The court can see from the transcript of the interview, at one point, Ms. Gutierrez just asserted her Fifth Amendment privilege without the assistant attorney. And when I mentioned to Mr. Bowles, I said, you're not really advising her to assert her Fifth. She's just doing it on her own. And he said, well, I think she can do that. So we have Ms. Gutierrez who doesn't understand the circumstances in which she gets to assert her Fifth Amendment privilege, just asserting it, and her attorney not counseling her on that. So the bottom line is, it took a long time to schedule the pretrial interview. That's the fault of Mr. Baldwin's counsel and Ms. Gutierrez's counsel, not ours. They listed her, I believe, initially on April 19th. We requested her pretrial interview on April 21st. We didn't create any delay at all. Her interview was scheduled, and Mr. Bowles did exactly what Mr. Baldwin's counsel wanted him to do, which was just have her assert the Fifth to everything. because they don't want her to testify. She is listed on their witness list and they presented her for a pretrial interview, but they don't want her to testify. They want to get her statements in as exceptions to hearsay. And certainly what the state is arguing to the court is that.
So what Karen Morrissey is saying here is what the defense is trying to do, she's arguing, is get into the record, get into evidence for the Alec Baldwin jury, statements by Halyna Hutchins that are favorable to their client without having to allow in statements that are unfavorable. So only one side of the Halyna Hutchins story. And they'll do that by taking statements that are hearsay, statements that were made outside of the Alec Baldwin trial, and introducing them in the Alec Baldwin trial for the purpose of asserting the truth of those statements. Now, these could be recordings. This could be live stream of her testimony. Well, she didn't testify in her own trial, but her statements in the interrogation. Other statements may be prison calls, any out-of-court statements. And they're going to say, well, these are exclusions to the hearsay rule, so they should be admitted. And there's a whole bunch. Hearsay is too complicated to get into. But some of these would be exclusions, like certainly the police interrogation, likely the jail calls would be appropriately excluded from the hearsay exclusion and be allowed as evidence. But then the state would only be introducing those statements, those out-of-court statements. And one of the problems, the reason we have a hearsay rule in the first place, is very straightforward. And that is that if you're introducing an out-of-court statement, and the witness, the person who made that statement, is not available, is not on the witness stand, well, then you can't cross-examine the statement, right? You can't cross-examine a video. So the state is saying, listen, if Halyna Hutchins, if her statements are coming to the record, she's got to be a witness. And we want the opportunity to cross-examine her if she's going to be a defense witness. Not just her recordings, but her. And if necessary, we're prepared to offer her use immunity so that she can't simply claim the Fifth Amendment to avoid that from happening.
The hearsay statements that the defendant wants to present to the jury, those are statements that have to do with Ms. Gutierrez's culpability, and they are absolutely.
Yeah, I do want to address that point. So Morrissey, when she's talking about, well, Halyna Hutchins in her interview was just asserting the Fifth Amendment privilege herself. She was not consulting with legal counsel. You are allowed to do that. You don't have to consult with legal counsel to assert. It's your privilege. It's your right. You can assert it. The point Karen Morrissey is trying to make here is not that she doesn't have the right to assert it. It's that you're only allowed to legitimately assert it if your response would be incriminating. There's a legal framework that applies. And because Halyna Hutchins is not a lawyer, she doesn't know this legal framework, and therefore she's asserting the Fifth Amendment inappropriately. Now, if she was only asserting the Fifth Amendment when her lawyer was advising her, there may be some presumption that the legal framework's being applied appropriately. But certainly when a non-lawyer is doing it themselves, it's not hard to imagine that she's applying her Fifth Amendment outside the appropriate legal framework.
Absolutely exculpatory to Mr. Baldwin, and they go to causation in this case. It's perfectly appropriate for them to present those statements. I'm not objecting to that or arguing that point at all. But what I am saying is that in turn, the state is also allowed to present testimony from Ms. Gutierrez that goes to Mr. Baldwin's culpability. She has probably more information than any other witness with regard to Mr. Baldwin's culpability. We are simply asking that we also be able to present testimony and evidence from Ms. Gutierrez. The defendant intends to do it. There's no question about it. So the first thing that needs to happen here is we need to have some kind of a question by question determination from the court as to which questions Ms. Gutierrez even can lawfully assert her Fifth Amendment privilege. Once the court decides, okay, this is the category of questions where I believe she can assert her Fifth Amendment privilege. Then we make a determination about whether or not she should have use immunity to answer those questions. That's not terribly difficult. Her pretrial interview, as the court can see, was relatively short. I think it was 20 or 30 minutes. So we need to have a hearing. We need to have the court determine, or the court potentially could even do it from the transcript. Have the court just determine what she needs immunity for. At this point, a lot of the questions that we would ask her, she doesn't even need immunity for. She's just a normal witness. She's on the witness list. She's been.
For example, if they were to ask her, if they were to ask Halyna Hutchins in the Alec Baldwin trial, do you know how the live round got in the gun? That could potentially be incriminating, and she could appropriately assert her Fifth Amendment privilege. And then if she does assert her Fifth Amendment privilege, they could potentially grant her use immunity. She could be compelled to answer that question, but her answer would not be able to be used against her in a future legal proceeding. But if they were to ask Halyna Hutchins on the witness stand in the Alec Baldwin trial, did you see Alec Baldwin press the trigger on the gun when it discharged? That doesn't incriminate her. It incriminates Alec Baldwin, which explains why Alec Baldwin's defense team doesn't want her testifying. But because it doesn't incriminate Halyna Hutchins, that would be a question to which she could not legitimately assert the Fifth Amendment, would not need use immunity to be compelled to answer.
Interviewed, we put her on the witness stand, we ask her the questions, and she's required to answer them under penalty of perjury. There's no reason when she's posed a question, for example, was Mr. Baldwin attentive during the firearms training that you provided? How does that trigger her Fifth Amendment privilege? What did your firearms training with Mr. Baldwin consist of? How does that trigger her Fifth Amendment privilege? So this is just something that we need to get ironed out so that the jury can have all of the information that the jury needs, that the jury is entitled to, and we don't create a situation where Ms. Gutierrez's statements only come in with regard to the exculpatory value they have for Mr. Baldwin. They also need to come in with regard to the inculpatory value that they have with regard to Mr. Baldwin. Thank you.
Mr. Baldwin. I mean Bowles, sorry.
Oh, Bowles is here.
Your
Great.
Honor, and as a preliminary matter, Judge, can you hear me?
What happened, Bowles?
Yes.
Judge, I want to make sure. Okay, I'm having poor internet connectivity, so I hope this
Classic
doesn't
Bowles.
affect it.
Ineffective.
Judge,
Ineffective
I want to start
internet.
by saying that first of all, the assertion of privilege was on behalf of Ms. Gutierrez Reed, who wanted to assert her privilege. It wasn't on behalf of anybody else. She has a currently pending appeal, as this court knows, so she has a conviction that is not yet finalized, and the cases are very clear. She can invoke a privilege as to questions that may tend to incriminate her. I agree with the state. She cannot invoke as to all questions if those do not have a tendency to incriminate her. However, when Ms. Gutierrez Reed invoked it on her own at the interview, Ms. Morrissey also said in the transcript, and she left that out in the interview, I think she can invoke that. So that's what happened there. That was May 14th. Your Honor, preceding May 14th, on or about May 8th, it was a confusing situation because Ms. Morrissey had told me that on a Sunday, an email that she would stipulate to unavailability, or thought she would stipulate to unavailability, so that the statements can come in through that exception. So I thought it was going to be a stipulation. Then there was confusion on the interview date. Then I had scheduling issues, so we got it set up. Next, Your Honor, on May 14th, we got the indication from Ms. Morrissey that she wanted to file a motion to force use immunity, which under Rule 5-116, this court unquestionably has that authority and discretion to do that. Now, Your Honor, in a normal case, and the cases cited in that rule, Bellinger and some others, this court can force use and derivative use immunity, which I do not believe should be selective, as the state indicates, because the problem we get in there is that on cross-examination, questions may be asked, then Ms. Gutierrez-Reed may have to invoke in the middle of trial. If that were to happen, her testimony could be stricken. So I think if this court were to order use and derivative use immunity, it would have to be blanket as to the trial testimony and cross-examination, I would submit, to avoid those issues. But Your Honor, that's in the normal case. This will be most likely the most publicized trial in the history of New Mexico, or at least one of them. And because of that, we have submitted in our briefing, this is not the typical case. If Ms. Gutierrez-Reed testifies, there's no current restrictions about what could be asked of her, including on cross-examination. That testimony will undoubtedly be watched by millions of people. Currently, Ms. Gutierrez-Reed is set for trial in front of Judge Ellington in August. We have moved to continue that, Your Honor, but that is a separate matter involving alleged bringing a gun into a bar. There's no protections as to Ms. Gutierrez-Reed on that trial, because even if this court were to order use and derivative use immunity completely, that testimony she gives will be watched and heard by potential jurors, and there's really no way to prevent that. Now, the government says we can do a motion to change venue if there's an issue. But again, that raises the issue, Your Honor, this is going to be widely publicized across not only the state of New Mexico, but the country. So that's a very real concern Ms. Gutierrez-Reed has. She's also, and the state really didn't touch on the separate Ellington trial, Judge Ellington trial, but that is a very real concern of hers, that if she's asked on cross-examination questions related to that, it really imperils her ability later to defend herself in that proceeding. We also have the appeal, Your Honor, which we don't know what will happen on that, but if it's remanded, the state gets a complete opportunity to cross-examine or examine Ms. Gutierrez-Reed on matters she would have never had to say going into that trial. So while the court unquestionably has the discretion, I would submit, Your Honor, that because she is unavailable and statements can be introduced by both parties, there is another way the court can handle this and avoid the potential constitutional issues that may arise in the future with her right to a fair trial in front of Judge Ellington, and perhaps in front of this court if the appeals court reverses this case. So I think there's another way this could be handled for the testimony to be obtained by both parties.
I'm going to allow the defendant to respond. I think that under State versus Brown, they can take a position. Let me read that case. All right, so I think that you can oppose the motion, and I'm going to listen to it. Go ahead.
Yes, Your Honor. So I will be brief. The issue that we have is with respect to the prejudice due to the timing of the state's request for use immunity. As the state has noted, Ms. Gutierrez-Reed was actually on the state's witness list as far back as February. She was also on the defense witness list. And you know, the state could have made this application months ago, because the situation is that Ms. Gutierrez-Reed did not testify in her own trial. And so there were no new statements that were available to the state after the trial that were not already available to the state for the past nearly 3 years. So they were aware of the situation. And they even, it sounds like from Mr. Bull's representations, the state even indicated that they were willing to stipulate to unavailability without taking her statement, which would have then, resulted in, the same position we would have been in without the grant of use immunity. But the state was aware of this. They were aware of this 50 witnesses ago. They were aware of this 3 years ago, and they had her listed. So at this point, the state now, as they're making all of these many numerous disclosures, they disclose us all of these, phone calls from Ms. Gutierrez Reed, again, that we cannot possibly have the time to go through in advance of a pretrial interview of her, because what the state is indicating is they think she has much more information than the statements that have already been provided. But we don't have access to those statements. We would need to interview her. So she's effectively becoming a new witness that now we would have to interview and prepare for her at trial. And so the state had every ability to do this sooner. And we would ask that the court consider some of the items that were also in that I know were contained in some of the other filings that the defense has submitted with respect to the volume of new disclosures that the state has made and the prejudice that the defense will suffer if we now have to approach this new, rather substantive witness when we're talking about just 10 days, 10
A new
business
witness.
days before trial. Additionally, the state has indicated that they requested her interview right away and they weren't responsible for any delay. I think that needs some clarification, Your Honor, because the defense initially had subpoenaed Ms. Gutierrez Reed for a statement. There were some scheduling issues based on availability. The defense actually was working with and contacting the prison facility, and we did have that set up, but then the interview had to be canceled based on availability of Ms. Gutierrez Reed's counsel, and she does have a right to have counsel present. So that had to be moved. In the interim, as we were setting up the next one, Ms. Morrissey indicated that she wanted a deposition instead of a statement. And so she needed to file a petition before the court. The defense took no position on that, but informed Ms. Morrissey that if that's something that she wanted, she would need to petition the court for that, as is the appropriate criminal procedure under the rules. She did not do so, but that did cause part of the delay. And then ultimately the interview was scheduled with Ms. Gutierrez Reed, did take place, and the defense also provided the information to the prison facility with the links for her appearance. And so we would just ask the court to note that there was nothing that prevented the state from petitioning this court for use immunity. And that is our sole objection at this stage, is the fact that they could have done this while we still had the time to conduct a full investigation of what her statements would be without prejudice to the defense. But now here we are in the 11th hour on the eve of trial, and the state is making motions for use immunity that will basically provide this witness who would be one of the most significant of the trial. And we are definitely prejudiced by this late request, and we would ask the court to deny the state's application for immunity, at least specifically with respect to the timing and the prejudice that this would cause the defense of Mr. Baldwin at this stage. And he is entitled to a fair trial and to an opportunity to prepare and present an adequate defense.
All right, before you reply, I have a question for Mr. Bowles. Is she going to use that use immunity, or does she just plan to not take advantage of it?
And Your Honor, I really apologize. It noted that my internet was having connectivity. I heard part of the court's question.
Does Ms. Gutierrez, all right, does Ms. Gutierrez, to your knowledge, have any intent to answer the questions if given immunity based upon that? I mean, I'm looking at the interview. She didn't cooperate.
Your Honor, she doesn't want to be cooperative in this case. I understand the court can order under use immunity, blanket use immunity testimony, but she does not want to answer the questions.
Reply, Ms. Morrissey.
Your Honor, if the court were to grant the motion for use immunity and Ms. Gutierrez were to refuse to follow the court's order, then she's held in contempt of court. Witnesses don't just get to refuse to follow the court's order. She refuses, she's held in contempt of court. We will be asking for additional jail time. That's how this goes. I will start by, it's baffling to me absolutely baffling to me that there is a defense attorney in this hearing opposing immunity for his own client. If that is not an indication that he is acting as an arm of Mr. Baldwin's defense team, I don't know what is. And
Right.
listen,
Your Honor, that's inappropriate.
I think it's absolutely true.
Okay, let's move on. Keep
It's
going.
actually not.
You all, it's her turn. Let's keep going.
Mr. Bowles has told the court, look, you know, it's really complicated, Judge, for us to do it the right way, for us to put her on the witness stand and have her, you know, outside the presence of the jury, or set a hearing and have her outside the presence of the jury, figure out what she can answer and what she can't answer.
Yeah, for anyone who hasn't guessed, there is no love lost between Special Prosecutor Carrie Morrissey and the Alec Baldwin defense team. They've accused her of lying, of engaging in all kinds of unethical conduct. One of the motions we'll hear later today, this afternoon, is alleging that Carrie Morrissey, the state, intentionally destroyed evidence to prejudice the defendant, and therefore the indictment should be dismissed with prejudice, never to be brought again. Alec Baldwin just walks away from all of this because of the bad faith conduct of Carrie Morrissey, who, remember, is not a career prosecutor, is a career defender, criminal defense attorney. So yes, she takes great offense at these accusations of being some kind of fascist arm of the state. And the defense has taken advantage of her criminal defense background several times. Asked her for favors, she grants the favors, and then after she grants the favors, they use it against her in motions. So yes, she's very unhappy with the state and with the defense and of the Baldwin defense, and of course, I don't think she cares about the Gutierrez defense. Jason Bowles, I don't think she thinks much of Jason Bowles. But is it a credible argument that Jason Bowles here is being used as an arm of the Baldwin defense team? How is it not in his client's interest to get immunity? How does that harm his client, for his client to get immunity? I don't get it. Now, you may want, the immunity to be constrained in some way or clearly defined so everyone's on the same page on what it covers and doesn't cover. That's fair. But clearly, the beneficiary of Halyna Gutierrez being denied immunity is not really Halyna Gutierrez. It's Alec Baldwin.
So you have to do it blanket. Okay, do it blanket. I'm not opposing that. Mr. Bowles' suggestion, if that's what he thinks is the best way to do it, you can absolutely issue blanket use immunity. She has to answer every single question under the court's authority. If she doesn't do it, she suffers the consequences of that. Mr. Bowles continues, even in the Baldwin case, to present information to the court that is patently false, and he's doing it again. He is in this hearing telling this court that these lawyers, the defense attorneys and the state, are going to be able to ask any question of his client. Well, the rules of evidence only permit us to ask relevant questions of his client. Every lawyer who questions Ms. Gutierrez at trial will be subject to the rules of evidence, will be permitted only to answer appropriate, relevant questions, those questions that are determined by this court to be appropriate. The Ellington case is just a red herring. There is nothing about that separate case that is relevant to this case at all. I would be stunned if the court found otherwise. This is a completely different thing. It didn't have anything to do with her participation on the movie set. She was in the city of Santa Fe as just an individual. She wasn't working, and it's absolutely ridiculous. Not to mention the fact that Ms. Gutierrez has another case pending in front of Judge Ellington because of her own conduct. So we don't turn around and say, state, you can't use her as an incredibly important witness because she's got this other case pending. She has another case pending because she seems to have committed additional criminal offenses. That's kind of the way it goes. With regard to Mr. Baldwin's argument that there is prejudice based on the timing, let me tell you, Judge, I was not aware that I was going to need a motion for use immunity. I was not aware that Mr. Bowles was going to show up to a pretrial interview and instruct his client to assert her Fifth Amendment privilege to questions that do not trigger the Fifth Amendment privilege assertion. Now, based on my experience with Mr. Bowles in the Gutierrez case, maybe I should have anticipated that, but I did not. So I didn't learn of that until we finally got the pretrial interview done. Ms. LeBlanc's statement about the short period of time that the state was considering asking for a deposition, that didn't create any delay at all. At that point in time, Ms. Gutierrez was already scheduled for a pretrial interview. That pretrial interview was never canceled up until Mr. Bowles indicated that he had scheduling difficulties. So the pretrial interview was scheduled. We talked briefly about having a deposition. We reached out to Mr. Baldwin's counsel. We asked for their position on that. They said they took no position on it. And I said, okay, I guess we'll set her for a deposition. Then they said, no, we're not opposing it, but we think that you need to get the court's approval. I'm not creating that delay. They're creating that delay. And at the end of the day, we said, look, we'll just go ahead and interview her on the day that she set, which was May 9th. Actually, I think it was May 10th. So we agreed we'd go ahead and interview her on that day. The interview was never canceled. Mr. Bowles canceled the interview. We got her scheduled on the 9th. Mr. Bowles canceled the interview. We were trying to get her reset. And because I sort of had this feeling like if you want something done right, you better do it yourself, I did it myself. And I finally ended up getting my pretrial interview, wherein Mr. Bowles unlawfully instructed his client to assert her Fifth Amendment privilege to nearly every single question that was asked of her. So to say the state should have just been able to anticipate this roller coaster ride is absolutely ridiculous. Now, with regard to the jail calls were provided weeks ago. I know how long it takes to listen to the jail calls because I've had to pay my investigator to do it. There are 2 lawyers on the state side. There are 10 lawyers on the defendant side, and they have at least 1 investigator. So if they can't get that under control relatively quickly, I'm not sure what to say. We are not, I want to make clear, we are not asserting that Ms. Gutierrez has a whole bunch of additional information that nobody's ever heard of. She is specifically being called by the state so that she can simply give the jury the information that she already provided to law enforcement and to OSHA with her lawyer's advice to waive her Fifth Amendment privilege. So those are the things that we're asking to get in through her testimony. There's one other statement that she made in a jail call that was specifically provided to the defense. They don't need to go listen to 300 and some of them to find that. We gave them the number. We showed them exactly where it was. Now, at the end of the day, when the defendant comes to court and says, Judge, we don't have enough time, we're prejudiced because we don't have enough time, I want to take the court back to the hearing that we had on February 20th, where we were talking about scheduling. And the court suggested that the trial be scheduled in October. And the state suggested that the trial also be scheduled in October. And it was Mr. Spiro, it was the defendant, who said, no, we need to have a trial in June. They wanted a trial last month. They got a trial this month, and they continue to come to court and say, Judge, we don't have enough time. They don't have enough time because they asked to have the trial set too soon in a case that has massive discovery. With regard to any of their complaints about all of these documents that have been provided, I have to tell you, Judge, you know, when they indicate in their arguments that they received this massive amount of discovery, what happened was we realized that not all of the lapel videos were in our possession and therefore were not in the defendant's possession. So as soon as we realized that, we got those videos from the sheriff's department, we uploaded them, we provided them, and we realized that the vast majority of those videos were duplicative. So what was happening is 2 police officers were conducting an interview. The defendant didn't have the lapel camera from one of the officers, but they did have the lapel video from the other officer who was present for the interview. So a lot of their complaints about this stuff was coming in late, they're really over exaggerating any potential prejudice that they could have possibly had from any of that. And again, they asked for a June trial because of my objection. The court gave them a July trial when we were intending to have an October trial. So if they don't have enough time, there is a remedy. They can ask for a continuance. Thank you.
Hear, hear. All right.
The court makes the following ruling to be
Yes.
followed up by an order of the court to be filed next week. The state denies the state's amended opposed expedited motion for use immunity for Halyna Gutierrez. It's pretty clear that she does not intend to cooperate. The court may grant use immunity pursuant to Rule 5116 if the court finds the testimony may be necessary to the public interest and the person has refused or is likely to refuse to testify. So it's really the public interest portion that I'm going to address because she has indicated that she won't testify. You've indicated that she possesses information about what she already told the investigators. I don't think that there is anything that, I mean, I haven't heard of anything that she might testify to that someone else could not testify to, even about her observations. Maybe, I mean, maybe the only portion is that talking about how Mr. Baldwin didn't want to be trained, things like that, which she could probably answer without the use immunity. But, you know, the state says, well, the simple solution after she refuses to answer, even though she's been given immunity, is that you can hold her in contempt. I'm not going to do a mini trial within a trial. And I think that when all is said and done, if she's going to be an unavailable witness, then we're at the 11804 evidence rule on unavailable witnesses. So I think you should prepare accordingly.
If I could just ask a point of clarification.
Yes.
Given that the court is denying the motion, the state still can ask questions of Ms. Gutierrez that do not trigger her Fifth Amendment privilege. So we can still have her transported. We can still put her on the witness stand. Does the court want to deal with what questions she has? She has the right to assert the Fifth to prior to trial, or do you just want to wait and do it then?
Right. I mean, I'm forecasting based upon what Mr. Bowles is saying, based upon that interview, that everything is going to be a non-answer, and then there's the unavailability of the witness.
Well, and we certainly will be renewing our motion, but I hear your ruling, and I'm not arguing with it. Thank you.
All right. Thank you. We're in recess in this case. Do you all want to take a break, or are we continuing? I see nods, but I don't know what that.
I would like a break.
Whatever's preferable to the court.
Okay, we'll take a what time is it? 10. We'll be back at 11:15. Okay. Thanks. Bye bye.
Thank you.
11:15. So what are they doing? Are they just
trial and say that he was subjective. They can't cancel.
Okay.
I see that in Odyssey.
All right. So I thought I was going to get a break. What are we doing? Oh, no, there's another one. State's motion for clarification of court's order amending another order. What is the other order? 421. Let me see if I can find out quickly before we dive into this. What happened on 421? Okay. I don't see in the court filings in amended 421. Oh, 421-23. Holy cow. All right. What is that from? Oh. Okay, so this requires some background. So Alec Baldwin, this is the second indictment of Alec Baldwin for the shooting death of Halyna Hutchins. Alec Baldwin had a first grand jury indictment brought by a first set of prosecutors, and that got messy. The special prosecutor appointed decided to also run for the New Mexico legislature, and apparently you can't have both jobs at the same time, and there were some other irregularities. And it was decided late in the day to have the gun sent to the FBI lab. So this was before Kerry Morrissey was appointed. So the decision was made to dismiss that first indictment. And it was made at the request of the defense, Alec Baldwin's defense team, because they came to Kerry Morrissey. This is one of the times they took, I would say, advantage of Kerry Morrissey and her defense attorney perspective as a career defense counsel rather than a prosecutor. They came to her and they said, Kerry, we hear that the pistol, the revolver, that was in Alec Baldwin's hands when it discharged and killed Halyna Hutchins, we heard it was just sent to the FBI labs to see whether or not it's possible the gun could have just gone off by itself. If it turns out that's true, that would be very exculpatory for our client, probably wouldn't get an indictment. Is it possible we could wipe away this first indictment and then wait for the FBI results to come in and then make a decision about how best to move forward, so that this indictment is not just hanging over our client's head when it may just, it may turn out the gun went off by itself. And Kerry Morrissey said, sure, as a professional courtesy, we'll do that. We'll dismiss that initial indictment. There's other problems with it anyway. We'll start with a clean slate. If we get the FBI results back and it says the gun could not be fired unless the trigger was depressed, then we reserve the right to impanel a second grand jury and re-indict your client. So what happened on April 21st, 2023, which is what this next argument about, that is, here, I can pull it up here. Oh, I pressed the wrong button. Hold on. Let's see if I have the right one. Yes. So this is the null pros motion filed by Jason Lewis and Kerry Morrissey. Jason Lewis was co-counsel on the Halyna Hutchins trial. I don't know if he's been dropped for the Alec Baldwin trial or not. I haven't seen his name a lot. But he was working with Morrissey on these prosecutions at this time, May 21st, 2023. And this is the motion they filed with the court to dismiss the case, the charges, the grand jury indictment against Alec Baldwin, the first one, without prejudice. See these words here? Oh, I can't highlight it. The bottom sentence. The case is dismissed without prejudice and the investigation is active and ongoing. So this was a professional courtesy by Kerry Morrissey to the Baldwin defense. Now, ultimately, they got the results from the FBI lab. The FBI said this gun was tested The hammer would not drop and fire a cartridge unless the trigger was depressed. Carrie Morrissey impaneled the second grand jury, presented the evidence to the second grand jury, got a second indictment, and that's why we're in court here today. So the second argument here is defense motion. Let's see. State's motion for clarification of court's order amending the 4/21/23 order, which would have been this, I guess, is what we're going to hear about. So let's take what happened. Here it is. So we had a short break. I think we still have, after this argument, for which there's an hour scheduled, we should have a lengthier, a couple of hour lunch break, I think. I hope. Okay, here we go. Let's see if I can catch up.
For inspection. I see that, I see that in Odyssey, the motion to dismiss indictment for destruction of evidence is listed twice. I think the first one is supposed to be the full and font.
That's
One
our
on one.
understanding too, Your Honor.
Okay, good. All right.
That's supposed to be the 2 o'clock to 4 o'clock Mountain Time.
All right. State's
Portion of
motion
today's hearing.
for in-camera inspection of joint defense agreement. State,
Okay, so maybe I was wrong. State's motion for in-camera inspection of joint defense agreement. So the state wants to know if Jason Bowles, defense attorney for Halyna Hutchins, has a formal agreement to cooperate with defense counsel for Alec Baldwin. Now they're not asking to see that agreement themselves, at least not now. They're asking for the judge to look at that agreement in isolation and determine if there's anything wrong with it that should be brought to the state's attention.
and the court is ready, state.
Your Honor, at this juncture, I believe, this is Erlinda Johnson. At this juncture, the counsel for Ms. Halyna Hutchins Reed responded that there is no written joint defense agreement. And so unless there is a written joint defense agreement, I think that moots the state's request for the court to inspect any joint defense agreement.
So on the record, are you withdrawing your motion?
Yes, Your Honor, but we would like confirmation from the defense that there is no written joint defense agreement.
Well, notably I'm sorry.
So confirmed.
Okay, so confirmed. All right.
So the state would be withdrawing that motion at this time.
Okay, please prepare that paperwork.
Thank you. Will do.
All right, let's go into the full and font motion if we're ready. Are we ready?
We are, Your Honor, and I will be handling that with the court's leave for the.
So I don't know what this is. The Foulin font. That sounds like it's a case law, like a citation to a court decision, appellate court decision. And I've never seen this guy, John Bash. Obviously part of the. This is a new name to me. Part of the Alec Baldwin defense team. Let's see. And that looks like actual office space.
Defendant.
All right, thank you. All right, so the motion is, get my motions here. All right, this is the motion, defendant Alec Baldwin's expedited motion for motion to dismiss the indictment for failure to allege a criminal offense. Okay, thank you.
Okay, so this is what was scheduled to be argued after lunch. So I guess I'm not getting a lunch break, and neither are any of you. So this is scheduled for an hour. Now, just to preface this, to provide some context, my understanding, so this kind of motion, a motion to dismiss an indictment for failure to state a criminal offense. Basically, the defense is saying, listen, if everything the state says is true, it still fails to satisfy the elements of the crime charged. So every criminal charge has certain elements. One of the elements of this involuntary manslaughter charge is essentially a mental state of recklessness. And my reading of the defense motions up to now is saying, listen, it can't have been reckless unless Alec Baldwin affirmatively knew there was a bullet in that gun. And no one's alleging that he knew there was a bullet in the gun. The state's only alleging that he knew there could have been a bullet in the gun because he knew it was a real gun. And therefore, because he knew the gun could be deadly, his conduct in pointing it directly at Halyna Hutchins without ensuring no live ammo in the gun and manipulating the hammer and the trigger, that's the recklessness that qualifies this as involuntary manslaughter. The state is saying, even if you believe all those things the state says, that he didn't inspect for live ammo, that he pointed the gun directly at Halyna Hutchins, that he manipulated the hammer and the trigger, that is still not enough for involuntary manslaughter unless Alec Baldwin knew for a fact there was a live round in the gun. Now, I would suggest that's not the legal standard for involuntary manslaughter. A good analogy, as I like to use, is to a drunk driving homicide. That's a classic definition of recklessness. Someone gets drunk at a bar, they get behind the wheel of their car, they're driving home. They're not intending to run anybody over, and all they want to do is get home. They don't mean any harm to anybody. There's no malicious intent. But they know that when they're driving drunk, they're presumed to know, because driving drunk's an inherently dangerous activity, just like handling a gun. They're presumed to know that when they're driving drunk, they're creating an unjustified risk of death or serious bodily injury to others. And if it turns out there's an old lady in the crosswalk when they come slamming through that intersection and they run her over and kill her, that's vehicular homicide. That's a reckless involuntary manslaughter. By the defense standard here, that kind of conduct, driving drunk and running an old lady over in a crosswalk, could only be involuntary manslaughter if the drunk driver knew the old lady was going to be in the crosswalk. That's not the legal standard, folks. The legal standard is the risk that's being created. But that's what I imagine what we'll be hearing from the defense here. So let's see what they have to say. And it may mean we wrap up earlier in the day since we didn't take a lunch break. All right, here we go.
Go ahead.
Thank you, Your Honor. And I haven't appeared before you before. My name is John Bash. I'm one of the attorneys representing Mr. Baldwin, and it's a pleasure to be here. One bit of housekeeping before I begin. I know we have a motion later today that involves witnesses. If you had a sense of when that will be, we can go ahead and start notifying the witnesses to be ready at a certain point in time, if that would be helpful to the court.
I believe after the lunch hour, this is probably going to take us to noon Mountain Time, this motion, or if it doesn't, we'll break at noon. And in other words, I'll call you back at 1, basically.
Okay.
So noon Mountain Time is in 40 minutes, folks.
Mountain Time.
Thank you. Thank you, Your Honor. And with that, I'll begin. May it please the court.
Yes.
We have moved under Rule 5601D to dismiss the indictment for failure to state a crime. And our submission, Your Honor, is pretty simple. Under State versus Henley, which is the New Mexico Supreme Court's authoritative construction of the involuntary manslaughter statute, that's at 2010 NMSC 39. In order to convict a defendant of involuntary manslaughter under New Mexico law, the state must establish the defendant's subjective awareness of a substantial risk that his or her actions could cause harm to another person. It's a subjective standard. It differs in that respect from certain other recklessness offenses under New Mexico law.
So this is probably a correct statement of the law. I think where the argument is going to be is in the definition of what we mean by substantial. So the defense, I think, is going to argue that because New Mexico law requires a substantial risk, that means that should be interpreted to mean a highly probable risk. In fact, I think they'll argue that it means a definite subjective knowledge that in this case there was a round in the gun or the old lady in the crosswalk. The state's going to argue that substantial means something other than speculative. It means there's substance to the risk. There's reason to know that the feared danger could occur. In this case, I would argue there's the substance is, it's a real gun that you're pointing directly at another human being, and you're manipulating the trigger and the hammer. That it doesn't mean you have to know there's a round in the gun. It means you have to know there could be a round in the gun. That's the substance. The gun is capable of firing the bullet. The defense is going to try to argue that, well, it's not a substantial risk on the facts of this case, unless Alec Baldwin knew, in fact, there was a round in the gun, and nobody had that subjective knowledge, and no one is claiming he knew that.
And our submission, the state, and I think we will show this, has abjured any ability to show that Mr. Baldwin had a subjective awareness of a risk that the firearm in this case was loaded with live ammunition. Without that essential piece, the state cannot establish the element of the offense. It's not a question, Your Honor, of evidentiary sufficiency. It's not a question of how different fact finders could view the facts. It's a logical, legal question. The state has said that guns kill people. That's true. They kill people when they are loaded with live ammunition. If the state cannot even allege the essential piece that he was subjectively aware of a substantial risk that it was loaded with live ammunitions, they cannot prevail. Now, Your Honor, there has been a dispute between the parties about the extent to which the state is bound by its factual assertions in the Gutierrez-Reed trial, and I'm going to go into that in a little bit. But I don't think the court actually even needs to address that dispute, because the state's concession is on the face of the opposition that it filed to this motion. I direct the court's attention to pages 14 and 15 of that opposition. I think it was filed on May 21st. In response to our argument that they can't prove, and they haven't even alleged, that Mr. Baldwin was subjectively aware of a substantial risk that the gun was loaded with live ammunition, they don't say, yes, we can. And I'll get into this more in a second, but they say two things.
Let me see if I can... So, definition of substantial. This is from Oxford Dictionary, so not a legal dictionary, but substantial, of considerable importance, size or worth. Importance, concerning the essentials of something. Well, it's the essential nature of a gun that it's an inherently dangerous instrument. You know it's a real gun in your hand. You know it can kill. It's not just the bullet. It's the gun. You know the gun is capable, has the substantive nature, character, of being able to fire a lethal round into a human being. I would be shocked if this argument was successful by the defense.
They say, well, if he had done that, we'd be charging him with second-degree murder. That is a concession that they do not think he did that they cannot allege that, and they cannot prove that. Second, they point to a bunch of other stuff he did. And we'll talk about that, but none of that other stuff poses a danger to another person unless there's live ammunition in the gun. None of it does. They can't prove that element of the offense. They don't even claim to, and it's clear on the face of their opposition brief. So let me talk just briefly, Your Honor, about the Fool-and-Font standard, because I know you're intimately familiar with it, but the parties have joined issue to some degree on what that standard provides. And the state's wrong about this, and I just want to clarify why they're wrong about it. The original Fool-and-Font case back in 1995, as I'm sure the court knows, said there was a distinction between questions of fact and questions of law, and that a pretrial motion to dismiss under, I think back then it was 5601B, now it's subsection D, was only proper for questions of law. And the state kind of clings to this distinction between questions of law and fact. But critically, Your Honor, in 2016 and 2017, in the Pacheco and Platero cases cited in our brief, that's 2017 NMCA 83 and 2017 NMCA 14, the Court of Appeals rejected the distinction between questions of fact and questions.
I mean, think about what the defense argument is here, really. The defense argument is you can take what you know to be a real gun, not check to see if there's ammo in it, point it at another innocent human being, right? No self-defense justification, nothing like that. You're taking what you know to be a real gun, point it at another human being, cock the hammer, press the trigger. It fires a live round and kills that person, and you have zero criminal liability. Does that sound right to anybody?
Questions of law. And you can see why. It's in any case where it's a question about the application of law to facts, you can always frame any particular issue as a question of fact or a question of law. So it's an unhelpful distinction. What the Court of Appeals said instead is take the undisputed facts in the case, whether alleged, whether the state stipulates to them, doesn't dispute them. Take those undisputed facts and ask, can the state on those undisputed facts satisfy the elements of the offense? And what the guidance that the Court of Appeals gave in Pacheco was that typically that inquiry will turn on this question. Can the state reasonably assert the availability of additional evidence to satisfy the elements of the offense? So it's no longer, Your Honor, an issue of whether it can be characterized as a question of fact or law. It's a question similar to motions to dismiss in the civil context of whether the undisputed facts show that the state cannot satisfy.
By the way, I'll mention as an aside, you'll notice they keep touching upon civil context law, like they were doing with estoppel earlier. That's because these are all civil attorneys. So the two big partners from Emmanuel Quinn, they're civil litigators, and most of these other attorneys are civil attorneys. They're not criminal defense attorneys, and that's coloring their arguments.
By the elements of the offense. And just to tie the loop on that, the state suggests that mental state questions like recklessness, knowledge, intent can never be the subject of a successful full and font motion. That is incorrect. In the published 2013 decision in Moreta, which we cite in our briefs and is at 2014 NMCA 60, the Court of Appeals did an intensive analysis of the facts alleged by the state to determine whether a full and font motion should be granted on a recklessness issue. There it was abuse of a nursing home patient by a doctor. So it is just not true that mental state can never be the subject of a full and font motion. It is true that it rarely is, but you rarely have facts like this where the state doesn't even allege that the crucial link between action and someone getting hurt, that the defendant had subjective awareness of that crucial link. That's pretty rare, and that's why this case is different. So, elements of involuntary manslaughter. And I don't think the state disputes this point. Under Henley, and the Henley case says this twice on page 108 of the Pacific Reporter, the defendant has to have subjective knowledge of the risk, of the substantial and unjustifiable risk that his or her actions will cause harm to someone else. I don't think that's disputed in this case. The state can correct me if I'm wrong. Critically, that's different than the way recklessness works under a lot of other statutes of this state. For example, the child abuse statute, which the Supreme Court just addressed a few months ago in the Taylor decision, has an objective standard. So it's what the defendant should have known. That's not true on involuntary manslaughter. The Supreme Court has been very clear about this. It requires subjective knowledge. What did the defendant actually know about the risk?
Well, he knew that there was a real gun in his hand that was capable of firing a bullet, and he didn't ensure that couldn't happen to Halyna Hutchins. He knew that.
So just putting those two things together, the full and font standard and the elements of involuntary manslaughter, the state's position cannot work logically. On pages 14 and 15 of their opposition brief, in addition to numerous statements they made on the record in order to secure a conviction of Ms. Gutierrez, their position is that no one could possibly know that there would be live ammunition on this set. They do not intend to argue, if their briefs and filings and statements are to be believed, that Mr. Baldwin had any subjective awareness of a substantial, not just any risk, a substantial risk that firearm was loaded with live ammunition.
Yeah, I was right. See, he's trying to argue that substantial means large. That's not what substantial means. Substantial means of substance, of meaningful, important, the essentials of something. It doesn't mean it has to be a large component of something. It's not speculative. It's not imaginative. It's not unforeseeable.
Ammunition. If not, they can't show that he was aware of a substantial risk that whatever he did, whatever they allege he did, could kill somebody or could harm somebody. Because a gun does not kill people unless it has live ammunition. It just doesn't work. It doesn't make sense logically, and they have no answer to that basic problem. Now, we've given the court a number of cases from New Mexico and elsewhere analyzing involuntary manslaughter in the context of a particular weapon or object. And although the postures were slightly different, the basic question was the same. Can these facts enable a reasonable jury to find involuntary manslaughter? And the courts closely analyzed the nature of the object. In one case, it was a knife. In one case, it was concrete, and what the defendant knew about the object, and found and analyzed it that way. And the same analysis has to be done here. And if this
So just another juxtaposition. Everybody remember the Kim Potter taser case? She was convicted of involuntary manslaughter. She didn't even have a subjective knowledge that she had a gun in her hand. She thought she had a taser in her hand.
the state doesn't, as they don't, contend that he had any idea there was live ammunition in that weapon, he is not guilty. He's not guilty as a matter of logic and law. And the trial is not going to be able to overcome that. Whatever other things they alleged he did, if he didn't know it had bullets in it, he cannot be guilty. If he didn't know the substantial risk that it had.
So as I said at the beginning, that was my expectation. The defense position is if he didn't know there were bullets in the gun, he had to know there was a bullet in the gun, he can't be guilty of involuntary manslaughter. That's akin to saying if the drunk driver did not know there was going to be an old lady in the crosswalk, it can't be vehicular homicide when the drunk driver runs her over and kills her.
Had live ammunition in it, he can't be guilty. Now, the state, Your Honor, essentially has three responses to this, and I'll just go over them briefly. One, the state links its position to an unpublished decision of the Court of Appeals in the Serna case. And in that unpublished and therefore non-precedential decision, the court canvassed a number of standards that it had previously used to resolve full and font motions. And the first one it canvassed or discussed was the question of fact versus law. And it said the defendant would lose on that standard. And the question in the case was recklessness in connection with reckless driving.
Hey, I've got no sympathy for this lawyer. I mean, he's making a legal argument. I don't think it's a great legal argument, but he's making it with a straight face. If I were in his shoes, let me put it this way. This guy's probably getting paid $1,000 an hour to make this argument and for all the hours he spent preparing this argument, whatever motions he worked on and so forth. He's getting well paid for this. I don't have sympathy for him. This is what lawyers, sometimes you have to make a weak argument. Sometimes that's the only argument you have. At least he's not doing this pro bono, folks, and he's not doing it on a public defender's salary.
But as I've discussed earlier, that standard has now been rejected in published decisions in Pacheco and Platero. So that is not a good standard. That was a non-precedential decision. It went on to apply the correct standard in the alternative, which was whether the undisputed facts show that the state cannot prove its claim. And there the facts were clearly disputed. The state disputed whether she had accelerated when she hit the pedestrian. There were disputes. Here, of course, at trial, we're going to dispute a lot of facts if it gets to a trial. But for purposes of this motion, we can take all of the state's factual assertions as undisputed, but they simply have not claimed that they can prove he had a subjective awareness of a substantial risk that the firearm had live ammunition in it. The second thing the state says, and they've said this a few times now, Your Honor, they say, well, if he had that knowledge, it would be second-degree murder. Okay, so a few things on that. One, they're just wrong about that. Second-degree murder requires a strong probability of death. If he knew there was a strong probability that there would be live ammunition in the gun and he fired it and pulled the trigger, which of course we dispute, that would be grounds for a second-degree murder charge. But substantial risk is a lesser standard. There's a significant delta between substantial risk and strong probability. So what they need to prove for this charge is that that he was subjectively aware of a substantial risk that the firearm contained ammunition. They don't even.
No, that's that's the defense argument, of course, that Alec Baldwin had to be aware of subjectively aware of a substantial. I always forget to do this. So that's the defense argument, that Alec Baldwin needs to have had a subjective awareness of a substantial risk that the gun had ammo in it. That's not the legal standard. That's not what the statute or the jury instructions say. The statute, New Mexico statute and jury instructions on involuntary manslaughter, say that Alec Baldwin had to be aware of a substantial risk that his conduct could result in death or serious bodily injury. It's not specific to ammo in the gun. He knows he's holding a real gun. He knows he didn't check to make sure there's no ammo in the gun. So you're holding a real gun. You don't know if there's live ammo in it or not. You pointed directly at another human being. You cocked the hammer. You pressed the trigger. Are you creating a substantial risk of death or serious bodily injury on those facts? Whether or not you know for certain whether or not that there's a real round in the gun. Of course, this is just the defense doing its job, but it felt like he was misstating New Mexico law there.
Even claim they can prove that. That's why it's not involuntary involuntary manslaughter. The other point on that, Your Honor, is that there's no rule that says any given factual scenario has to be able to satisfy every gradation of homicide. I mean, there are certain scenarios that are murder or nothing, based on the facts. And even if they were correct, which they're not, about the second-degree murder point, that would not establish that they can show involuntary manslaughter without showing anything about his subjective awareness with respect to the risk of live ammunition. What's really, I think, telling about the second-degree murder argument is what I alluded to earlier, which is that argument shows that the state does not contend it can prove that he was subjectively aware of a substantial risk that the firearm contained live ammunition. They said it in black and white. We would have charged him with second-degree murder if that's what we thought. They can't prove it. They don't pretend to prove it as a logical matter.
Now he keeps coming back to the same point over and over again, and that just shows the weakness of his argument.
They simply cannot prove the legal elements of this offense. The last point they make, Your Honor, is they refer to a bunch of other alleged actions by Mr. Baldwin. And they say that those alleged actions are enough to satisfy the elements of the offense. So there's two things to say about that. One, none of those alleged actions pose a substantial risk to the life of another person if the gun is not loaded with live ammunition. They say he knew it was a real gun, okay? They say he pointed it and pulled the trigger. They say he didn't participate in a safety check. Again, this is not a civil suit under the ordinary negligence standard. This is not a suit for violation of the SAG guidelines. This is an involuntary manslaughter charge. And under this state's law, that requires subjective awareness that what he's doing poses a substantial risk that it could kill somebody. Pointing and pulling a trigger when you have no awareness that the gun has live ammo in it, that there's no risk that it has live ammunition in it, does not pose that risk. Admittedly, this is an unusual case. Most people.
I'm going to rewind that because I want to hear that again. Let's see if I can. I want to hear this again. Maybe my editors can use this as a short. He's saying that pointing what you know to be a real gun at another human being without checking to see if it's loaded, cocking the hammer, pressing the trigger, dropping the hammer on the chamber, that's not creating a substantial risk of death or serious bodily injury to that person. Can't be involuntary manslaughter unless you know for a fact there's a round in the gun. Let's hear that again.
Pulled the trigger. They say he didn't participate in a safety check. Again, this is not a civil suit under the ordinary negligence standard. This is not a suit for violation of the SAG guidelines. This is an involuntary manslaughter charge.
Here we go.
And under this state's law, that requires subjective awareness that what he's doing poses a substantial risk that it could kill somebody. Pointing and pulling a trigger when you have no awareness that the gun has live ammo in it, that there's no risk that it has live ammunition in it, does not pose that risk.
Good luck. Good luck with that argument.
admittedly, this is an unusual case. Most people, when they encounter a gun in their home or somewhere, have reason to believe it might have ammunition, because ammunition typically goes with firearms. They're often preloaded with ammunition. In the typical defendant case, they're going to know that. But the reason the state won't allege that here is because it was a movie set, and this was a prop. And he was told by the people responsible for it that it was a cold gun. And the state told the jury, in order to secure a conviction of Ms. Gutierrez, that everyone on set believed it was empty. They told them that. They cannot come into this trial and say that he was subjectively aware. And to their credit, that's why they're not arguing that, because they can't. They know that's not true, and they know it would contradict what they said. So those are their three arguments. I want to briefly, and I just touched on it, talk about their prior representations. As I said, I don't think the court, to resolve this motion in our favor, even needs to get into that, because I think the state has effectively conceded in their opposition brief that they cannot prove that he was subjectively aware of a substantial risk that the firearm contained live ammunition. I think that's enough. But if the court does get into those prior representations, we've given the court a number of federal cases saying that it's a due process violation for prosecutors to take inconsistent views of the facts in two different cases arising out of the same event. Of course, there's exceptions if new evidence arises. For example, if they got an acquittal in the first case and they realized, no, we were wrong about that, we're going to take the jury's views to heart, and we're going to reassess our understanding of the evidence. That's not what happened here. They used a series of representations to secure a conviction of a person. And they sort of stunningly come into this court and say they're free to walk away from those and adopt totally factually inconsistent positions. I was head of a prosecutor's office for 3 years right across the border from El Paso to Austin. And I can't imagine us ever saying in a court filing, we can take diametrically opposed positions on the facts of two criminal defendants. I would never have let an AUSA do that. We've quoted them in our brief, and I won't go on extended about all the ways in which what they're saying now is inconsistent, but just a couple, Your Honor. In their opening argument, and this is at Exhibit F of our motions in this case, they told the Gutierrez jury in opening that the prospect of live ammunition on that set was incomprehensible. You can't square that with saying that he had a subjective awareness that what he was doing could kill somebody.
But they're not saying he had a subjective awareness.
They said it's a hard and fast industry rule that live ammunition should be miles away from a film set at all times. They said the gun was checked right before it was handed to him. This is in summation. Ms. Morrissey told the jury, in order to secure a conviction of somebody, that when Halls announced cold gun, that led everyone to believe the gun contained only dummy rounds. She said the crew didn't believe there were live rounds on set. They believed that she was going to do her job. They believed that she did her job. She said, imagine I hand you a gun and I tell you it's basically empty and I walk away when in fact I put live ammunition on that. None of that is consistent with saying Mr. Baldwin had any subjective awareness that anything he did with that gun could hurt somebody else. It's totally inconsistent, and they should not be in the business of adopting factually inconsistent positions. Just a couple more, Your Honor, and then I'll get close to wrapping up my presentation, because I know we have a lot to do on today. They've been inconsistent in other ways. In summation, the prosecution said it was completely foreseeable that Mr. Baldwin would manipulate the gun the way he did. But now they're saying that what he did was so out of bounds as to satisfy the standard of criminal recklessness, even though they said it was totally foreseeable on a movie set that he would do that. They said Ms. Gutierrez Reed had no supervisor when it comes to weapons and gun safety on the movie set. But now their claim is that Mr. Baldwin should have micromanaged her. At least I think that's their claim from these new producer theory allegations. So the state has been inconsistent. As I said, Your Honor, I don't think you need to go there, because I think they've made clear on the face of their opposition brief that they will not try to prove that he had a subjective awareness of a substantial risk that the gun was loaded. They just don't think they need to prove that. And they said, well, we would have charged him with second-degree murder if that's what we thought we had to prove, or if that's what we thought he did.
Well,
Two other quick ones.
They don't think they have to
A
prove
lot of
that.
their brief, Your Honor, is focused on the SAG guidelines. And it's a very, very strange sequence of arguments, because they spend a number of pages saying that he was supposed to attend the check under it's like Rule 12 of the SAG guidelines that are in the record. But I mean, if you just look at the face of this rule, it says the actor may attend the check. And if you look at the testimony they solicited from their own expert, Carpenter, at Gutierrez Reed's trial, he said this is just a dog and pony show, or it's to give a warm and fuzzy feeling to the actor. It's not necessary. And then you get about halfway through their brief, and all of a sudden they say, well, yeah, it's true. They don't actually require this. But this isn't a trial under the SAG guidelines. I mean, all that's right, but the SAG guidelines are totally irrelevant to this. I mean, whether he did the thing he can elect to do under the SAG guidelines has nothing to do with his subjective awareness that that gun in his hand could kill somebody. They also say, well, he's different than every other person on that set, every other producer, because he had the gun in his hand. He's not different in the respect that matters for this element, which is, did he know that the gun in his hand could kill somebody? If anybody on that set knew the gun in his hand could kill somebody, they would have said, oh, stop, this is crazy. And that gets, I think, to my final point before I briefly address this new producer.
Well, if anyone on the set had known that he was going to point that gun directly at Halyna Hutchins, they would have said stop. That wasn't in anybody's control but Alec Baldwin's control. And of course, the SAG guidelines are relevant. They're relevant because they enumerate the ways in which a gun is dangerous and that it should never be pointed at anybody. He was aware of those rules, had been for decades, and he did it anyway. Recklessness is the knowing disregard of a risk, an unjustified risk of death or serious bodily injury. We know he was aware of the risk of pointing a gun directly at another person because it's in the SAG guidelines, and we know he was taught the SAG guidelines. So, of course, they're relevant. He's not charged with the crime of violating SAG guidelines, but the guidelines go to his mental state.
Theory, which is that each of the actions, Your Honor, that they say shows his recklessness and shows that they can satisfy the elements of the offense, pointing the gun allegedly at somebody and pulling the trigger, not attending a safety check, he knew it was a real gun, all those alleged facts that they assert in their motion. It's not only that they don't they don't satisfy the element of subjective awareness, it's that they cut exactly the other way. No one thinks Mr. Baldwin or anyone else on the set wanted to hurt anybody. The fact that they assert, some of this we can test, but the fact that they assert that he was pointing and pulling the trigger, that confirms that he had no subjective awareness that there was a live round in the gun. No one thinks he wanted to hurt anybody on the set. The facts they cite as satisfying their burden under that element show exactly the opposite. They show that they absolutely cannot show that he had a subjective awareness that that gun could kill somebody. No one thinks he would have pointed and pulled the trigger if he knew that, if he knew there was any risk of that.
So this is, again, this is so funny. But again, to analogize back to my drunk driving example, right? So somebody gets drunk at a bar, they drive home, they run over an old lady in the crosswalk and kill her. Okay. And they're charged with involuntary manslaughter. This argument right now is akin to the defense lawyer for the drunk driver saying, we can't find him guilty of involuntary manslaughter of that old lady in the crosswalk because the only reason he was driving drunk is because he didn't want to hurt. He obviously didn't have any subjective belief that he could hurt somebody, or he would have called an Uber. So, I mean, you can tell by his own conduct, it can't have been. The involuntary manslaughter conduct invalidates the criminal charge of involuntary manslaughter.
So the facts they cite show exactly the opposite of what they cite them for. Last point, Your Honor, they've raised this new producer theory. It's not totally clear to me exactly what they're saying, but I think they're saying one of two things. The first one is they might be alleging some sort of supervisory liability, even if Mr. Baldwin had no awareness. He was negligent in supervising Ms. Gutierrez-Reed. Now, there's a ton of factual problems with that. That wasn't his responsibility, but those are not relevant for this motion. What's relevant here is that there is no supervisory liability criminal statute. You can't establish the mens rea, the subjective awareness based on a supervisory theory. That can't possibly work. The other thing they might be saying is that he should have known. He should have known the gun was loaded or something. You know, they haven't articulated this, but it seems to be what they're saying. But again, it's not that standard. He must be subjectively aware. He must have subjective knowledge of the risk. And that's clear as day in Henley. That decision's controlling. And for that reason, they can't meet their burden on this. So we reserve time for rebuttal, of course, but we respectfully ask this court to dismiss these charges because Mr. Baldwin is innocent as a matter of law. Thank you.
All right, before the state responds, I have a couple of questions over some of what you presented. So you said that that you can take the undisputed facts under full and fought. And I'm interpreting that to mean that you can ignore the disputed facts. And I don't read full and font to be that.
No, Your Honor, the way I would describe it is you give the state everything they're alleging. So some of those facts are undisputed and some of those facts may be disputed. So for example, there's a dispute about whether he pulled the trigger. Give the state that, obviously not at the trial, but for the purposes of this motion, give the state those disputed facts. Assume they can prove. The way Pacheco describes it is there a reasonable probability that they can obtain evidence to prove those elements? So if they, as long as it's not totally ridiculous, if they say this is a disputed fact, we think he pulled the trigger, give them that for the purpose of the full and font motion. Can they prove the elements even with that? And our submission is that no, they cannot, because they don't even attempt to allege that he had a subjective awareness of a substantial risk that that firearm was loaded with live ammunition. So give them everything else they say. Give them the disputed facts. They don't dispute that. It's clear on the face, pages 14 and 15 of their op. They do not dispute that.
What about the disputed facts? You talked about that they've raised additional facts. What about all the case law that says if you have disputed facts, it's for the fact finder? It is not for the court.
Your Honor, that's true only where the disputed facts, if resolved by the fact finder in favor of the state, could satisfy the elements of the offense. Our submission today is that assume the fact finder resolves every disputed fact in the state's favor. They do not contend he was subjectively aware that the gun in his hand could kill somebody, because they don't contend that he was subjectively aware that there was any substantial risk that it had live ammunition in it. So give them everything else they say. Give them they pulled the trigger. Give them he didn't attend the safety check. Give them all that for the purpose of this motion. Assume the jury resolves all of that in their favor. They still can't meet the elements of the offense. And that is the essence of a full and font. I would call it a Pacheco motion, because Pacheco really refined the standard, but that's the essence of the motion presented to the court.
One of the law self-defense members, one of the law self-defense members in the member chat is mentioning that, Baldwin knew guns were dangerous because he's on a gun control. He's on the board of a gun control organization. And it just made me think, here they're saying it's not the gun that's dangerous. You can point the gun at Halyna Hutchins and cock the hammer and pull the trigger without making sure there's no ammo in the gun. As long as you're not aware that there's actually ammo in the gun, that's all fine. But I noticed that Alec Baldwin's not on the board of an ammo control organization. He doesn't say guns are fine. How about own all the guns you want? Second Amendment. It's ammo that we need to control. That's what I'm worried about. It's the ammo that's the danger, not the gun. The gun's fine. Just a thought.
Right now.
All right. Well, let me read from Henley, because you read a certain portion of Henley, but there's more to Henley, and it says criminal negligence required for involuntary manslaughter for a jury instruction includes the concept of recklessness, in which a defendant consciously disregards a substantial and unjustifiable risk that harm will result from his conduct. The Uniform Jury Instruction on Criminal Negligence incorporates this definition, defining criminal negligence as existing when a person acts with willful disregard of the rights or safety of others and in a manner which endangers any person or property. UGI 14133. Likewise, the instruction on involuntary manslaughter states that the defendant should have known of the danger involved by his or her actions. 14231. To be convicted of involuntary manslaughter, a defendant must have been aware of the risk caused by his or her conduct and continued to act. So I'm curious as to how you're narrowing that, because they're broadening that. And they're saying, look at all this other evidence that shows that he should have known. Number one, he had a bad armor that he's responsible for hiring. He should have known that she was a bad armor. Number two, he was aware that Halls periodically checked the gun, which implies that he also knew that he didn't check the gun from time to time. I'm trying to remember what else. The SAG guidelines that they don't completely rely on, and I think you said that they rely on. If you said completely, they rely on them in part, and they're saying that as an actor, he, despite all that other information, that as an actor, he is not supposed to be pointing a gun at someone.
Boom.
and there's no need to use the gun, and that he pulled the trigger when he was pointing a gun that he didn't need to point to. So I'm curious as to how you have limited it to he has no knowledge because he got to rely on his armorer, he got to rely on David Halls, and you're ignoring all this other information that circumstantially, which is allowed, would indicate these elements. And that seems to be the core of what the jury is going to decide. And I'm not clear on how you're reconciling these kind of cases. A defendant's not, in fact, Murrieta, which you rely on very heavily, it says, State versus Murrieta. Defendant's argument both below and on appeal amounts to a disagreement as to how the fact finder should interpret the facts alleged. Such interpretations benefit from the opportunity to observe the testimony of witnesses, judge their credibility, weigh the evidence, and hear the parties' arguments after the close of evidence as a jury would have. Such contested facts, questions of fact in criminal cases rest within the exclusive province of the jurors. And then also in Murrieta in paragraph, that was 17 in paragraph 18. Furthermore, defendant's knowledge of intent generally presents a question of fact for the jury to decide. So to me, and you did acknowledge that they have additional facts, and under the case law that I'm reading, additional facts can equal disputed facts, and if you have disputed facts, you don't get full and final. And these additional facts are disputed facts, regardless of whether the state says, well, these other ones we dispute now. I'm just concentrating on the additional ones. And to me, it seems that this is at the core of whether the jury believes your facts about the armor and David Halls and that he had every reason to be able to rely on them, and the state's alleged facts that he was a producer, he knew about, he should have known about the armor, all these things. I'm not getting into whether it's true or false. I'm just wondering how you're reconciling these things.
Let me take a stab at that, Your Honor, and let me give you the short answer and then the slightly longer answer from both case law and the record. The short answer is add up all the facts that they say are disputed. Assume they win those. It still doesn't meet the legal elements of the offense. So you can imagine even.
So, folks, because we're behind a bit, I'm going to move it up to 1 1/4 speed. I should have done this earlier. My apologies. But that's why people will sound like they're talking faster, because they are, because of me.
It's easier cases than this, where something ridiculous. There's a murder charge, but the person's not dead. And no matter what else is disputed, they're obviously not going to be able to prove a murder charge if the person's not dead. It doesn't matter if there's disputed facts. In this case, and let me pick up on Henley. Your Honor quoted the carryover paragraph from pages 107 to 108 in the Pacific Reporter. The very next sentence, the first full paragraph on page 108, gives the standard that's at the heart of our motion. It says, our case law has long interpreted the requirement of subjective knowledge the requirement of subjective knowledge into the showing of criminal negligence required by our involuntary manslaughter statute. Later in the same paragraph, it says criminal negligence in the context of involuntary manslaughter requires subjective knowledge by the defendant of the danger or risk. So the parts that Your Honor quoted are the model instruction. We don't take issue with any of that. They may also have to prove objective knowledge, which is the should have known standard. But the subjective component, whether it's an independent component or part of what willful disregard and conscious disregard means in this context, it's clearly a requirement of the statute. I don't hear the state to disagree with this point. I mean, they can read the case just as well as anybody, and I don't hear them to disagree that subjective knowledge is a requirement under the statute. Now, Your Honor asked about these different factual allegations, whether the Halls check was insufficient and so forth. Our submission is that even if all those were true, just as a logical matter, if he is not subjectively aware of a substantial risk that there's live ammunition in that gun, and they don't allege he is, he cannot satisfy that element of the offense, because the only way that gun can kill somebody is if there's live ammunition in it. They can allege whatever else they want about he violated the SAG guidelines or he did this and that. But if they can't allege that he has plausibly, that he was subjectively aware of a substantial risk that the firearm contained live ammunition, they simply cannot meet the elements of the offense. I know Your Honor asked about Murrieta. That case in the quote Your Honor presented says generally intent is a question for the jury. And we have no dispute with that. I mean, in most cases, recklessness, knowledge, intent, that's going to go to the jury unquestionably. But where the state cannot allege, does not even purport to be able to prove an essential link, namely that the defendant understood that his actions had a substantial risk of hurting somebody else, it should not go to the jury. The rule 60, the rule, 5601D standard is there because the judge is a critical gateway on allowing defendants to be prosecuted for things that are not crimes. What they have alleged here is not a crime. You cannot be guilty of involuntary manslaughter if you had no awareness of a substantial risk that what you were doing could harm people. And in the case of a gun, in this very unusual case of a prop on a movie set, where everyone, according to the state, believed it was empty, you cannot satisfy the mens rea for involuntary manslaughter.
Again, the analogy here would be that you can't convict someone of drunk driving, homicide, involuntary manslaughter for driving drunk and running granny over in the crosswalk, unless you had substantial knowledge that there would be a granny in the crosswalk when you blew through the intersection. Not the strongest of arguments.
Thank you. State's response.
Who is it, Carrie?
Your Honor,
Maybe.
as a preliminary matter, I want to ask the court. I know that the defendant filed a request for supplemental briefing, kind of along with a supplemental brief yesterday, and we provided our response to that at around midnight. Is the court permitting the additional briefing? I hear Mr. Bash arguing the law and the facts that are in the additional briefing. So I just want to know what I'm responsible for.
No, I did not see that, and it's late. So,
Okay.
Your Honor, can I just respond? I mean, other than the brief mention of the producer theory, I don't think anything I argued had anything to do with the supplemental briefing.
So he's right, but that's important because he said the state's new theory of him being a producer. Judge, you even know about it, so it's not new because I believe it came out during the Gutierrez trial, and as we indicated in our response,
here's what we're doing. Here's what we're doing today. What I received and what I set for hearing. So a supplemental briefing that arrived yesterday is not on the table in my decision.
Understood. Thank you. I'll go ahead and proceed with my response.
I love this judge.
The circumstantial evidence that the state intends to present that goes squarely to this issue is Mr. Baldwin knew he had a real gun in his hand.
Yep.
Mr. Baldwin specifically asked for the biggest gun that was available. Mr. Baldwin knew and understood that dummy rounds look identical to live ammunition. That's the foundation. So before Mr. Baldwin has ever even encountered training by Ms. Gutierrez, that's where we are. He then arrives to his training with Ms. Gutierrez and doesn't pay attention. Not only did Ms. Gutierrez indicate that he didn't pay attention, Ms. Zachary actually took a video of him not paying attention. And it's one of the exhibits that will be used in the destruction of evidence motion later today. So he decided not to pay attention during his training. Then, and look, anybody who looks at Ms. Gutierrez understands that Ms. Gutierrez hasn't been alive long enough to legally own firearms. So there has to be some question about, is this person really qualified to have this job? Any reasonable human being would have that concern, and many of the crew members actually mentioned that to the producers. How can this lady be our armorer? She's like in her early 20s. So Mr. Baldwin certainly understood that. He had a bad armorer. She wasn't doing proper safety checks. His experience in the film industry is absolutely circumstantial evidence that he knew that when she was doing these safety checks that she wasn't following the rules. Absolutely, the court is right. He also understood that Mr. Halls was not checking the gun with Ms. Gutierrez every single time. We know that he knew that because that's what he said to law enforcement on October 21st. So we get to this point. Now let's take into consideration that there are two other actors on set that Mr. Baldwin can see dry firing their guns into the ground 10 times after the gun is handed to them by Ms. Gutierrez to ensure that every single round is inert. Are those actors on my witness list? No. Do I have plenty of other witnesses who are going to come in and say, we saw those people dry fire their guns into the ground every time she handed it to them? Absolutely. Plenty of witnesses are going to testify to that, and Ms. Gutierrez herself should be able to testify to that based upon the court's ruling because that certainly wouldn't be anything that she could assert her fifth to. So that's where we find ourselves at this point in time. Now, what Mr. Bash is telling the court, which is absolutely false, what he's telling the court is, unless this gun has a live round in it, it is completely harmless. And he didn't realize that there was a live round in it. Patently false. Mr. Baldwin himself, as I recall, had a conversation with law enforcement, and I may be wrong. I've read a lot of transcripts. He indicated an awareness that if he is handed a gun that has a blank round in it, but also has a barrel obstruction, that is fatal. That can kill someone and has historically killed people. I believe that that is the circumstance of the death of Brandon Lee, that almost everybody who works in the film industry is familiar with. So Mr. Baldwin didn't necessarily have to know there's live ammunition in this gun. He had to understand that the gun is real. Real guns are dangerous. Dummies look exactly like live ammo. Even if there's not a live round on set and she put a blank in instead of a dummy and the gun had a barrel obstruction, Halyna Hutchins is dead.
Boom. Well put, Carrie Morrissey.
She's dead. And she's dead because he didn't participate in the safety check. And listen, we agree, and we have always agreed that under the SAG guidelines, which do not dictate New Mexico law, the SAG guidelines indicate that that is optional. He chose not to participate, and I'm sure that's a decision that he's grown to regret. So he chose not to participate in that safety check. Then he decided to point a gun at a human being, cock it when he wasn't told to cock it. And we have plenty of video of him cocking guns when he wasn't supposed to, when he hadn't been told to, when the scene didn't call for it. And then, of course, he pulled the trigger, killed a woman, and seriously injured someone else. So that's the landscape, and the court is absolutely 100% correct. The defendant has spent pages and pages and pages and pages arguing, we don't agree. We don't agree to the facts. There are really no stipulated facts. The state isn't stipulating that in order for that gun to have killed someone, it had to have live ammunition in it. Everybody knows that's not true. Now, let me clear up a couple of other issues. The reason that these safety rules exist, the entire reason that the SAG Safety Bulletin #1 exists, is because of the risk that live ammunition could find its way on set.
Yep.
If there was absolutely no chance that live ammunition could ever find its way onto a movie set, why have these rules at all? You've got two actors standing right next to Mr. Baldwin who certainly understand that there's a significant risk of live ammunition, or they wouldn't be firing their guns into the ground right in front of him. Now, our expert, Brian Carpenter, will testify, and testified before the grand jury, and I think he even testified during the Gutierrez trial, that as an armor, he himself has found live ammunition on a movie set. So what Mr. Bash alleges with regard to the distinction between involuntary manslaughter and second-degree murder really, I don't think gets him where he needs to be. If I am an actor and I have reason to believe that I understand that there is a substantial risk that there is live ammunition on a movie set, and I take that gun and I point it at a person and I cock it and I pull the trigger, that is second-degree murder all day long. We can argue about that all morning, but that's not going to change. You know, I think that where the parties disagree here is when Mr. Bash was talking about the link, the link between the subjective knowledge and the offense, the link between the conduct, the subjective knowledge and the offense. We disagree on what the link is. Not only do we disagree on the vast majority of the facts, we disagree on that link. This motion by Mr. Baldwin absolutely cannot be granted by this court. There is a plethora of case law that says you can't do it. And what is happening here, which is what frequently happens in this case, is the defense attorneys are coming forward to the court and they're saying, they're making statements that are not at all based on the evidence or the future witness testimony. One of those statements that was given today, of course, is Mr. Bash's statement, this gun can only kill someone if it's got live ammunition in it. Absolutely false. And Mr. Baldwin knew that was false. So we need to simply rely on New Mexico law. We have an extraordinary amount of circumstantial evidence that goes directly to this point. Some of that evidence you may see this afternoon because it's relevant to another motion. The court, if the court in Cerna, which is the unpublished case that the defense, that the state cited, that the defense was certainly aware of, they were aware of Cerna, they were aware of Gomez. They didn't cite him because they were hoping, I guess, we wouldn't find him. So when you look at Cerna, there's a video. There is a video of a person driving and a pedestrian stepping out in front of them. And the only dispute between the parties is exactly what Mr. Bash is bringing to the court's attention today, which is, with substantial risk, how can you get there when you look at this video and all this lady, she wasn't speeding. All she did was just kind of make this turn and hits this pedestrian. And for heaven's sakes, it was an accident. And in that circumstance, the court said, no, there are disputed facts. There are disputed facts here. And we are asking the court to follow well-established New Mexico law and deny the defendant's motion. Thank you.
Response,
Your Honor.
reply, Mr. Bash.
Thank you, Your Honor. Much of what the government just said is incorrect, but as an umbrella point, much of what the government just said is waived. It appears nowhere in their opposition brief, the point about blanks, the point about what two other actors were doing on the set. There's been a lot of sandbagging in this case. It's not proper for when we make an important dispositive motion, the state not to present those arguments in their written submission and then to debut them for the first time at argument. The arguments are wrong, and I'm happy to address them, and I will in a second. But a lot of the points you just heard are not found in the brief of the state, and that you can't raise something, an oral motion, for the first time without previewing it. So let me take each of those points in turn. Ms. Morrissey went over a lot of their allegations, and some of them just have obviously no bearing on the issue before the court. Whether he selected the biggest gun, whether Ms. Gutierrez looked too young for the job, that has no bearing on whether he had a subjective knowledge of a substantial risk that the gun in his hand could kill somebody. They've given a lot of facts. Let's give them all those facts. Let's give them all the jump balls. Let's say that they're right about everything they say. That does not establish the element of the offense. And we've been over some of those in the opening presentation, that he had the gun in his hand, that he knew dummies look like live rounds. The fact remains that they told a jury to secure a conviction that everyone on that set did not believe there were live rounds in that gun, and that it was inconceivable there could be live ammunition on that set. And everyone includes Mr. Baldwin. Now, they've raised two arguments. I guess they've realized that they have a big problem, because if they can't show that he had a subjective awareness that that firearm was dangerous in his hand, they can't prove their case. And so they've raised two totally new arguments.
It's dangerous.
Which were not in the opposition brief. Someone can correct me if I'm wrong. I'm doing it from memory, but I don't remember seeing these arguments in the opposition brief. First, they say that Mr. Baldwin saw two actors dry firing their guns, but they're not going to call those actors, but they saw it. I don't see that anywhere in the brief. Second, they say that it's not true that you need a live round. In certain circumstances, a blank could kill someone because there could be an obstruction in the barrel and it could go off. But no one contends, Your Honor, that he thought there was a substantial risk that that gun contained blanks, because as everybody knows, and I'm sure the court is very familiar after sitting through the Gutierrez trial, they look completely different than dummy rounds. Dummy rounds are the ones that look like live rounds. Blanks look totally different. And I'm not aware the state has ever contended that Mr. Baldwin was aware of a substantial risk that Mr. Halls or Ms. Gutierrez loaded blanks into that gun, which looked totally different. It's not even remotely realistic that that was a risk after two professionals loaded the gun, that they accidentally loaded it with blanks. So that is an argument that the state just made up at argument. They didn't even.
Wait. It's not credible that experts would confuse blanks and dummy rounds when they managed to confuse blanks and dummies with live ammo. We know that happened. Live ammo doesn't look different. And the way they inspected the gun was to open the cylinder gate and spin the cylinder and look at the rear of the cartridge. The cartridges were not removed from the gun. And from the rear, blanks and dummies can look exactly the same.
Included in their written briefs, and it's completely preposterous in light of the reality of what blanks look like. It's an argument to try to get past a dispositive motion that doesn't actually have any weight. I would just add that I think they would have a huge problem with the foreseeability element if their theory was that he foresaw that there could have been obstruction that could have injured somebody. but actually what happened was totally different, and so he's guilty. I don't think they could satisfy foreseeability, but at any rate, the argument's waived, and it's factually ludicrous given that these things look different. There's no way he could have had a subjective awareness that there was a risk they were putting blanks into that gun. Ms. Morrissey referred to the SAG guidelines, and they say we have these prophylactic rules under the SAG guidelines because, you know, there's some chance of live ammunition, and so you can never say there's no chance. Again, let's assume she's right about all that. I don't want to get into whether she's right about the purpose of the SAG guidelines. The standard is not no chance. The standard is a substantial risk. You heard it again. They can't argue substantial risk. They can't argue subjective awareness of a substantial risk. They would have charged second-degree murder if they thought they could argue it. So they moved the goalpost, and they've moved the goalpost to, well, we can't say there's no chance. I mean, there's always some 0.0001% chance of anything happening, but that's way far away from the element of this offense, which is substantial risk. She doesn't argue that properly because she can't argue that. She changed the goalpost. I heard her say something about the second-degree murder. Well, you're just wrong about that. Mountains of case law say you're wrong. There was no case law cited. There was no logical reason given. Second-degree murder in this state requires a substantial probability. If the state could allege that Mr. Baldwin thought there was a substantial probability that there was live ammunition in the gun, and it could satisfy all the other elements, that would be a different story. But what we're saying is they haven't even alleged a substantial risk. There's a big delta between strong possibility and substantial risk. And if they can't even allege that, then it's not involuntary manslaughter. It's an accident for which he's not criminally liable. I heard Ms. Morrissey say that there's a plethora of case law that says you can't do a full and fond motion in these circumstances. There's not. They don't cite it. They just keep saying there's a plethora of case law. Moreta stands for the exact opposite proposition. It says generally they're not going to be successful. We have no truck with that. Of course, generally the prosecutors are going to be able to get intent to the jury. But this is an extraordinary case where they're charging somebody with an accident based on a movie prop when they told another jury that everyone thought it didn't have live bullets in it. This is an unusual case. And Moreta would have had one sentence of analysis if the rule was you can't succeed on a full and fond motion on a question of intent. It didn't. It went very carefully through the allegations, and there was an attached affidavit, and it went very carefully through all that and said, okay, the state has enough here to prove the case. So they're wrong about that. And finally, I mean, Ms. Morrissey says, well, I know why the defense didn't cite Serna because they're scared of it. I mean, it's an unpublished non-precedential decision that alternatively applies a test that the Court of Appeals rejected in 2 published decisions. Okay, so it's not controlling. And it does alternatively apply the correct standard, which is what the undisputed of facts allow the state to prove. And I mean, it was just a case with completely different facts. She said it's exactly the same thing. It's not. One of the facts disputed in that case, which was a vehicular case, a reckless driving case, was whether the defendant had accelerated at an unreasonable rate right before she hit the pedestrian. That was an actual factual dispute that goes to recklessness, and that could be dispositive. In this case, the state does not claim that he had a subjective awareness of a substantial risk that the firearm contained live ammunition. It's not disputed. For everything that Ms. Morrissey just said, they were not disputing that. She was candid. She did not sit here and say they can dispute that. There's a reason she didn't. They know they can't prove that. They know it would be inconsistent with what they told the jury to get a conviction of somebody else. They can't prove that. If they can't prove that, they can't establish the elements of the offense. And with that, I'll sit down, Your Honor.
All right.
Court makes the following ruling. The court denies the full and fond motion of the defense. The court finds that, first of all, there does exist disputed facts before the court that are not capable of dismissal as a matter of law. The disputed facts are appropriately before the jury. The involuntary manslaughter talks about the defendant should have known of the danger, and I think that's really at the core of what is argued, that Mr. Bash is saying there's no way he could have known, so there's no way he should have known. And Ms. Morrissey is saying here is some circumstantial evidence as to how or why Mr. Baldwin should have known.
And by the way, just as a clarification point, folks, we're hearing here about circumstantial evidence. It's common for people to perceive circumstantial evidence as somehow being inferior to direct evidence, like eyewitness testimony, for example. Circumstantial evidence is just as capable and compelling as direct evidence, sometimes more so. Often eyewitness testimony is the weakest kind of evidence, and that's direct evidence. So there's nothing defective about or deficient about circumstantial evidence by any means. Circumstantial evidence is perfectly good evidence. And by the way, anytime we're talking about a person's mental state, we're always talking about we don't have mind reading machines. We can't look into someone's brain and have direct evidence of what their state of mind is. We're almost always talking about circumstantial evidence. We're making inferences about their mental state from circumstantial evidence.
With respect to the inconsistent theories of prosecution, you didn't really bear that out. I don't think you've met your burden. I think that the 10th Circuit, U.S. versus Negro, is on point where it's got to go to the core, prevail on due process claim. It's got to go to the core, and that it's got to be, which is so inherently contradictory. And I think that I think part of what the state's relying on is what Ms. Gutierrez didn't do. Okay, and the court will prepare that order as well. I will see you back here at 1 o'clock. Does that work for everyone?
Your Honor, before we recess, I just have a question. The defense mentioned that I'm going to be arguing the Trombetta motion. We have 3 witnesses. The defense indicated they have witnesses. May we ask who they plan to call for that? I don't know their witnesses.
Yes, Your Honor. As always, it somewhat depends in part on who the state calls. It may be that we don't have any witnesses if they're calling the same witnesses. So we notified Corporal Hancock, Mr. Ziegler, and Mr. Haig. But if that's the same set of witnesses that the state's calling, we of course will be efficient with the court's time and not recall people.
They are, Your Honor, same witnesses.
Okay,
So
very
then
good.
we will, yeah.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
Real quick, Mr. Spiro, are you referring to Michael Haig or Luke Haig?
Luke Haig.
Okay, all right, thank you.
All right. Thank you.
Thank you.
We're in recess.
All right, folks, we are in recess. Now, I had tentatively planned to do a part 1 and part 2 show, but I don't think I will. The judge is indicating she'll be back in 40 minutes. And we got 1,000 people here. So I think we can talk about various aspects of the case for 40 minutes. I'll check out the various comments and questions.
Thanks for joining School of the American
Whoops.
Rifle. This is part 2 of
Oh, whoa, sorry. That is not appropriate. What happened? Did the feed just end? Well, if the feed just ended, I might just have to do a part 2 show. Let me see. Or did I just hit the wrong button? No, okay. The state just rescheduled for part 2. So I guess we are doing a part 2. Yeah, that was an Armor's YouTube video on AR rifles. So pretty good too. In fact, let me see if it's still up. I recommend their stuff. School of the American Rifle. They do pretty good stuff. So check them out on YouTube. School of the American Rifle. I was looking at they were doing an autopsy of a couple of Palmetto State Armory AR rifles. Very informative. I own several Palmetto State Armory AR rifles. They're a great bargain. So of course I was curious as to what the quality checks might reveal. All right. So folks, I'm actually going to take a break for a few minutes, hit the restroom, grab a sandwich for lunch, and I'll come back for part 2. Part 2 is already scheduled on YouTube, and I will, the state is saying 1 o'clock Mountain Time, which is in about 36 minutes, 35 minutes. So we'll be back for that. With that said, I will, oh, you know what? Let me take a quick look at the member comments here. I don't know if I'll be able to get to all of them. I'll try to address the substantive ones. Take a few minutes to do that. That's at lawofselfdefense.com/members. Anybody can become a member for 99 cents, folks. 99 cents for a 2-week Law of Self-Defense membership. You'll immediately be emailed instructions how to join us on the member live stream and the member chat, where you get your questions addressed for free. Or if you're on YouTube, you could try a $10 super chat. Let me check the super chats, actually. And there is one. So let me address it real quick, and then I'll get to the member questions. Derna, 1804, $10 super chat. Thank you very much. Derna says, every time Baldwin is flagging someone with a firearm in these clips, could that be? Oh, that was from yesterday. I already addressed that. It's all right. So just the members then. Welcome to our newest member, Danny. Yeah, Danny got my instructions on how to join us in the live stream. So that's great. Let's see. Just checking. Yeah, I know. Yeah, during the interrogation of Hannah Gutierrez by Detective Alexandra Hancock, she revealed to Jason Bowles that she used to be a Hooters waitress. And he got very interested in Detective Hancock after he learned that. A Hooters waitress. He was a lot more interested in that than when his client was being interrogated. Cycle Boy says, Andrew, new video review for you. Chicago man chases out a burglar with an iron pan. I think it was an aluminum pan. I saw that video clip. It had a dent in it afterwards. If that was a Lodge cast iron pan, there would have been no dent from hitting someone in the head with it. I'll see if I can check that out. Oh, and you sent the link. Good. Okay. So I'll see if I can. I did see the video on Twitter. And I think I bookmarked it, so I'll put that on the list for things to maybe address next week. Cycle Boy says, with the DWI example of accidentally killing while DWI, so a reckless vehicular homicide, reckless manslaughter, could Baldwin claim non-intentional intoxication type of thing with DWI? The trouble is, I believe his legal liability is fixed when he knows he's holding a real gun. And he knows he's pointing it directly at another person in violation of safety rules. He knows he hasn't ensured there's no live ammo in the gun, and he knows he's cocking the hammer and depressing the trigger. So that's all intentional on his part. So I don't see the non-intentional. For this to be an accident in the legal sense, and I spoke to this when I did my first legal analysis of this October 21st, 2021 shooting of Halyna Hutchins by Alec Baldwin. I did my first legal analysis the next day, October 22nd, 2021. And I said then, if it turns out there are facts that this was a genuine accident, there is no legal liability. But what would a genuine accident look like? It would look like a piece of the set collapsed onto Alec Baldwin, and that's what's induced the discharge of the gun. But nothing like that happened here. That would be unintentional. Let's see. Phil says a firearm doesn't kill. A person pointing the firearm at another person and pulling the trigger kills that person. Yep. Let's see. Checking. The use immunity went against the state in the sense that the judge said, I'm not going to just grant use immunity now in a pretrial hearing. When Hannah Gutierrez is called as a witness, if she's asked a question by the state and she refuses to answer based on the Fifth Amendment, I'll make a call then whether or not the Fifth Amendment applies, is my sense of what the judge ruled. It was a little ambiguous because there was an exchange with Carrie Morrissey and the judge after the judge issued her kind of ambiguous ruling, where it seemed to me Carrie Morrissey was saying, hey, but if I call Hannah Gutierrez as a witness and I ask her a question, there are questions I can ask, the answers to which would not fall within Fifth Amendment privilege. Or if they do, we can discuss use immunity in the moment. My sense was the judge was saying yes. Now, that said, it's pretty common for judges to say, hey, if you're thinking of calling a witness and we know ahead of time that witness is just going to plead the Fifth, I'm not going to bother letting you call them because it would be pointless. So maybe that's where we're at here. But frankly, it was left ambiguous to me. Certainly, the judge did not denied the state's pretrial motion request for use immunity of Hannah Gutierrez. No question about that. Let's see. A quote from John Adams, Paul in Florida. Quote, facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passion, They cannot alter the state of facts and evidence. John Adams. I can think of a couple of Richard Feynman quotes that would fit well there too. Let's see. Phil says, how does this analysis jive with pointing a replica firearm at someone being pretty well accepted as an objectively reasonable assumption of a lethal threat being presented for justifiable self-defense? I'm not sure what's being asked there. If someone's pointing a replica gun at you and you perceive it as a real gun, you're allowed to respond in self-defense to reasonable appearances. From there, what's relevant is your mental state, not the mental state of the person pointing the gun. They may know it's a replica, and they may know they're not presenting a threat of death or serious bodily injury, but for purposes of your self-defense justification, what they're thinking doesn't matter. What matters is your reasonable perception. Jim asks, Andrew, could the prosecution ask for greater included offenses being included as opposed to lesser included offenses? Lesser included offenses are generally, well, they're known what they are. Of course, that's documented ahead of time. What's a lesser included offense of some higher level crime? And the parties are on notice that the lesser included offenses are open game. Greater included offenses, no, you can't go up the scale. The highest you can go up the scale is what you were indicted for. Or if it wasn't an indictment, an information, whatever charge you were initially dragged into court over. Let's see. Lawful to Shoot says, I think this lawyer, the one we just saw, Peter Bash for the defense, could convince a weak jury to find Baldwin not guilty, which would be a travesty of justice. But that's actually the state's position. The state's position is basically, well, the defense can make all these arguments to the jury. The defense argument is we don't want to have to make these arguments to a jury. We want the judge to find in our favor as a matter of law without it going to a jury. Let's see. Phil asks, should any inference be made by the immediate court orders, the judge's decisions regarding the defense motions? It's just that trial's coming up. It's only, a couple weeks away now. And the judge may not want to take time to do a lengthy order in response. She's giving her answer now, and probably she's going to reduce them to a written order, but they'll probably just be like one page, a paragraph each. Use immunity was not ordered by the judge here, so she denied the state motion, but I already stepped through that. All right, folks. So at that point, I will remind all of you, that was all the member questions. I'll remind all of you that if you carry a gun, so you're hard to kill. That's why I carry a gun. So I'm hard to kill. So my family is hard to kill. Then you also owe it to yourself and your family to know the law, so you're hard to convict as well. We got 1,000 people here. So I'll just remind everybody once more that you can get a free copy of our best-selling book, The Law of Self-Defense Principles, at lawofselfdefense.com/free book. Check it out on Amazon, 5 stars, 1,500 or so reviews, but don't buy it on Amazon. They'll charge you for the book and shipping and handling. We only ask you to cover the shipping and handling. We give you the book for free at lawofselfdefense.com/free book. Explains in plain English how use of force law works. Most people say they read it in an afternoon. The biggest compliment we get on this book is that it's easy to read. It translates the legalese into plain English. We give it away, folks. lawofselfdefense.com/free book. All right, so I'm going to sign off, grab something to eat, and I will be back at the top of the hour, a few minutes before the top of the hour if I can manage it. The top of the hour is when the court comes back into session. There's already a part 2 show scheduled in YouTube, and I'll throw it up on the Law of Self-Defense live stream as well. All right, folks, until half an hour or so from now, 25 minutes from now, I look forward to seeing all of you back then. Take care.